after vacation. पूरा लिखे रखो 31 after vacation.
But in praying for inclusion in the list, my lord.
Motion matters.
Yes, my lord. My lord, may I pray for non-prosecution of a matter? My lord, the matter has been pending since a long time. It has become infructuous.
Give it. Hey, it to be mentioned in Yasun for non-prosecution. Yes.
My lord, may I be permitted to mention, my lord, two matters, my lord. One of which my lord, your lordship was pleased to, my lord, fix it on 8th September, my lord, in respect of which I have handed over the wrong slip, my lord, on the last date, my lord. And my lord, on the other matter, my lord, your
What is that wrong number?
my lord, this is the correct number, my lord. The wrong number, my lord. The other matter, my lord, pertains to the grant of lease, my lord. In respect of which your
No,
lordship
give the right slip.
yes, my lord.
And just in the backside, give the wrong number which has been mentioned yesterday.
No, my lord. I have mentioned two matters yesterday, my lord. One of the matters, my lord, your lordship was pleased to fix it on my lord 8th September. And my lord, in relation with the other matter, my lord, your lordship was pleased to direct me to bring my own brief. Where from my lord?
That you don't want to know. That you don't want.
Yes, but no, my lord. I have also brought my brief, my lord, in order to satisfy your lordship, my lord.
Then you said that you have mentioned with a wrong number.
Wrong number means, my lord, the matter that has been fixed by your lordship on 8th September, my lord. The wrong slip I have.
Instead of that,
Yes, my lord.
this has to be listed on 8th September.
Yes, my lord. This is the correct slip. And my lord, the other matter.
No, then in the slip where the wrong number has been mentioned.
No, wrong number. There is no question of wrong number, my lord. This is the handing over of the wrong slip inadvertently, my lord, on my by me.
In the previous slip, the case number has been rightly written.
The previous slip, my lord. And my lord, the previous slip, my lord, that I have handed over, my lord, this is the second one, my lord.
Wise.
And my lord, the second matter, my lord, in respect of which your lordship was pleased to direct.
What is the urgency?
My lord, already, my lord, a long-term lease, my lord, for a period of 99 years has already been granted in my favor. And my lord, I am in possession. The land, the lease was executed, my lord, in the year 1952. And my lord, since then I am in possession, and in the year 2022, my lord, a long-term lease for a period of 99 years had already been, my lord, executed, and the rent, my lord, towards the rent towards the lease, my lord, had already been paid by me in the year 2025. In spite of that, my lord, on the said land, my lord, the respondent authorities had constructed a pump, my lord, without my permission. And my lord,
give this slip. Give this slip.
Grateful.
It's September.
My lord, these two matters may be listed on 8th September, my lord. Grateful to you.
May I be permitted to mention?
8 September, 8 September under the heading fixed motion.
My lord, may I be
serve notice. Afresh. Yes, sir.
My lord, may I be permitted the item number 66 assigned matter? That is very.
Yes. Why are you mentioning, sir?
My lord, the written examination.
66 of what?
Today's list.
It is at what stage?
The petitioner is filed the.
At what stage it is now?
Final disposal, my lord.
Very difficult, sir.
No, my lord.
Please, complete.
Everything is complete. The petitioner filed an SLP under instruction of the coordinate bench of this honorable court, and the respondent authorities also filed an affidavit before the Supreme Court of India, and with admittedly they have approached the
What
Honorable
is the
Supreme
matter
Court.
about?
Matter about the declaration of a candidate, wrongfully declaration of tainted candidate. And subsequently, the School Service Commission admitted that that has been done wrongfully.
So we have not been permitted to sit in the written examination.
7th is the last date. 7th is the date of examination.
Only hearing matter that I cannot,
My lord,
because my diary are all got congested.
kindly, my lord, once.
Had it been a motion matter, I could have understood.
Tomorrow, my lord, kindly, my lord.
Not possible, sir.
Otherwise, the matter will be infractious, my lord.
What can be done, sir?
My lord, well, only
Not
chance, my lord.
possible.
Kindly, my lord.
Sorry.
My
Yes,
lord,
kindly, my lord.
No, no, I'm sorry.
my lord,
Humble.
I cannot take up now.
2 times, my lord, this honorable coordinate bench of this honorable court released this matter.
So you have chosen me. I don't have any. I don't have any work apart from your case.
No, my lord, please, my lord.
How do
Humble
I?
request, my lord.
Impossible.
Only one.
Benson tomorrow I shall see.
My lord, last
Benson
date is
tomorrow.
7th is the last date, my lord. Please, my lord.
7th of which?
This month.
No, 7th cannot be. It's a,
7th is the written examination. Date of written examination.
if you are a tainted candidate, you have been rightly
No, my lord,
excluded.
not at all. It
No.
has been admitted.
I'm not convinced.
It
Sorry.
has been admitted, my lord. Please.
No,
It is a
sorry.
my lord,
humble
two
Yes.
new
request.
motion matter, my lord. New motion matter, my lord.
Keep.
My
Sorry,
lord,
ma'am.
please,
Sorry, sir. I cannot
my
give you
lord,
any
please,
precedence.
please, my lord.
Everybody is urgency. I cannot.
So, my
Sorry.
lord, it is very much urgent, my lord.
I understand, sir.
Supreme Court has been directed.
If you want, I can also release
My
the
lord,
matter.
also,
Call
honorable.
the list.
Your Lordship, I am for the petitioner, Your Lordship. It is a panchayat matter, Your Lordship, due to a
The instant matter is
My lord, item number 2, I am for the petitioner, my lord. Pursuant to my lord earlier direction, I have served the copy, my lord. My lord, kindly peruse page number 4 of my affidavit of service, then page number 8 of my affidavit. The addressee has refused to accept and send it back at page number, which will reflect from page number 8 of my affidavit of service. Page number 4 is the earlier order, and page number 8 is the affidavit of service. My lord, kindly see 23rd August 2025 at page number 8.
page number 4.
Page number 4 is, my lord, the earlier order. Pursuant to my lord, the earlier order, I have served, my lord. Page number 8 is the report, my lord, dated 23rd August 2025. Direct deposit on addressee instruction, and that has been returned back to me.
What is the postal envelope?
Postal envelope, my lord. My lord. left, my lord, the
না খুলো না একদম that means this gentleman is no more the commissioner.
my lord, that has no, I don't have, my lord.
Yes, yes.
If I search in the website, my lord, the name of this present incumbent is being displayed in the.
You go to the Howrah Municipal Corporation and find out who is the present commissioner. Mr. Mukherjee, who is the present commissioner of Howrah Municipal Corporation? Ah, you have given a wrong. That is why it has been returned. Look, the affidavit of
I am for the alleged contempt, my lord.
who is for the petition?
Long order operative portion at page 24.
Page 24.
Right.
Paragraph
26, 27 and 28.
Yes, Mr. Banerjee.
Lord, order dated 8th May communicated on 19th May with the direction of paragraph 29, 6 months from the date of communication. In my humble submission, it is premature, my lord. After expiry of 6 months only, my lord, the cause of action for contempt arises.
My lord, why?
Why?
Because, my lord, dear lordship has specified in paragraph 29, preferably within 6 months
by this
from the
time,
date of communication.
I have to be allowed, but
Give me a
before
second.
that-
Give me a second.
Page 25 is the communication, my lord. 19th of May.
At the time of hearing,
My lord, may I? This order is to allow the petitioner. My lord, prior to allowing me, there are some formalities that was also noted in this order. My lord, the clearance certificate, unless they provide or intimate me, saying that subject to clearance of environment and other many things, then can, my lord, I will be allowed to excavate. Otherwise not. My lord, by this time, after 4 months, they have not done anything. That's why this contempt. Well, after 6 months, if I give the letter of intent, thereafter also 3 months will go.
it will be again extended.
That
If
is
that
the
is
problem.
so, if they are if have you deposited all papers?
Yes, yes. All papers.
After getting this order, you have deposited.
Everything, everything. In spite of
Uh,
that, they are not.
At the time of hearing,
Lord, may I seek an indulgence? I have sought an indulgence from my learned friend. Lord, maybe come back to your lordship, Lord, on Monday or Tuesday, Lord, for this matter. There is I'm in little personal difficulty today.
Very good.
Uh,
There is a motion stay.
Yes,
it is a motion stage, my lord. It's a
They-
fixed motion.
Report was called for. They have
Report
filed
called
a
for,
report and they have
exception
taken-
filed.
Yes, they have
So, my
taken an
lord, kindly keep it on Tuesday, subject to your lordship's convenience, and
Hey, Kullan Babu.
Tuesday, Monday, whichever date. Or Tuesday, my lord. Tuesday অসুবিধা? এই Monday ও চাইছি।
আচ্ছা, ঠিক আছে।
Monday, my lord, Monday. Or Wednesday. Wednesday is Wednesday. Wednesday, my lord. ঠিক আছে।
Question.
But I am appealing for the petition.
Hearing for 3 and 4, your lordship.
But here I am challenging the order passed by the special land acquisition officer, that is page 53. My lord, which has been passed.
Give me a second, ma'am.
Whether it will lie here, will not kindly once verify, because the cause of action entirely is within the district of Darjeeling.
My lord, as per these Honorable High Court's order, the special land acquisition officer Darjeeling passed the order. My lord,
Give me a second. Which order is under challenge, madam?
page 53.
So why before the principal bench?
My lord, as per these Honorable High Court, this order has been passed. Page 53.
No. Honorable court functions at circuit bench also.
My lord, that is true. My lord, my
Then
learned friend,
why
all are
before this
appearing.
court?
The order which was passed on 8th of August 17,
Ah.
at that point of time, circuit bench was not functioning possibly.
Agree that, yes. Whatever may.
As my,
Now the circuit bench is
Okay.
functioning.
Function.
as my lord,
Asul,
all are.
the subject matter of
Facilities.
For the petitioner, my lord, being led by Mr. Parthovi. My lord, in this matter, my lord, and the petitioner bought the purchased the, my lord, the land. Classification of the land was by, my lord. Subsequently, he purchased.
give me a second.
My lord. Right.
Yes.
At the time,
Adjust the microphone.
my lord. At the time of purchasing the land, my lord, the classification of that land was by, my lord.
By
By, my lord. Subsequently,
BID.
BID, my lord. In the year 2013, my lord. Subsequently, in the year 2015, the land was converted to Vastu, and that conversion certificate is annexed as P2, my lord, at page 15. My lord, after that,
Page number 15.
page number 15, my lord, 15.
15.
15, my lord. My lord, subsequently, in the year
Just a
2000
minute, sir. Give
my
me a
lord,
second.
my
Yes, Bastu Bastu.
lord.
That is in LR plot number 652.
652, my lord.
Very good. Then what happened, sir?
My lord, in the year 2017, at page, my lord, annexed as 16 page as annexed P3. My lord, the land was acquired, my lord, and the
Page
classification
number 16.
16, my lord, 16. Next page, my lord.
Yes. Plot number 652.
Yes, my lord. And the
Yeah.
classification is shown as Krisi, my lord, agricultural land, my lord.
But it is RS plot.
Yes, my lord.
But it is LR plot.
652, my lord.
RS and LR are same.
No, my lord, not same, my lord.
Then
Uh, Lord, in the same plot, my lord. The same plot is same, my lord. Actually,
RS plot has been converted to LR plot number 652.
652, my lord. Yes, my lord. That is.
Yes.
Yes, my lord.
Then what happened?
Then, my lord, the conversation.
Here it has been here it has been described as Krisi,
Krisi, my lord.
agricultural land.
Yes, my lord. Agricultural land.
Huh.
My lord, the compensation amount was also disbursed, keeping in mind that the land is agricultural land.
Who has disbursed the compensation?
My lord, National Highway Authority acquired the land, my lord.
In,
Is appearing.
so if you are agreed with the quantum, then go before the arbitrator.
Deeply obliged, my lord.
My lord, one writ petition was previously also preferred, my lord. That order is not annexed, I guess. The order is annexed as
Disclose the details of the compensation assessed for acquisition of the land.
yes, my lord.
So what is your grievance?
My grievance is, my lord, only that I duly converted the land from Baid to Bastu, my lord. But it was not reflected somehow, my lord, and the compensation amount is not proper, my lord.
So you have grievance with regard to the quantum of compensation. এই ন্যাশনাল হাইওয়েজ একটা দিকে এই যে সামনে রয়েছে বইটা দিন আমার you go through the book, sir.
My lord, they have
Subsection 5 of Section 3G of the National Highways Act.
If the amount determined by the competent authority under subsection 1 or subsection 2 is not acceptable to either of the parties, the amount shall on an application of by the either parties be determined by the arbitrator to be appointed by the central government.
I agree, my lord. Ultimately, it's all about the amount, my lord. But actually, the thing is there, my lord. I have communicated to them, my lord, that my conversion was duly done, my lord. But they have disbelieved the conversion certificate itself.
No, what is your prayer then? You're considering the prayer after holding the land of Atho for affording instead of Atho and to ask. So you are agree with the compensation? No, sir. Ashut, take down. Both the writ petition Yesterday you didn't turn up. Why?
Lordship, I lost my father, my lord.
Oh.
So I was not here.
Sorry.
My lord, today also, my lord, most humbly, my lord, I'm
I
paying
convey my deepest condolence to you and your family.
the last occasion, my lord, lordship has passed an order to direct the state, my lord, to serve a copy, my lord. My lord, I could not do it, my lord. My lord, I'm extremely, my lord, tendering apology, my lord.
What copy, Mr. Rai?
My lord, to the state, my lord. On the last occasion, state did not appear, my lord.
State appear today?
No, my lord. So I
We have served?
no, my lord. And
Oh, I see. It's all right. এই এখানে আমরা জিপি সাহেবকে তো ডিপার্টমেন্টকে জানাতে বলেছিলাম, সেটা কি হলো? ফাইল কি নামেনি? হ্যাঁ, 8 নম্বর প্যারাগ্রাফটা দেখুন। আপনি নামাননি নাকি ফাইল? নোট রাখুন, ফাইল যখন ফিরে আসে। On behalf of the writ petition, an accommodation has been paid for.
I have received the report of the railway just now. I want to file exception on that.
May I be permitted to file the report? My lord, a similar issue has already
Give me
been
a second.
decided by your lordship, my lord.
What is your exception against the report of the state?
I will file both the exception.
Then after vacation is better.
My lord, may I be permitted to file
Yes.
my report, my
Give. On behalf of the respondent numbers 1
There
to
is an interim order. That's why, my lord, because now after the affidavits, I can say or I can submit the plots have been acquired, fully acquired. We were not.
no, then it has to be hard earlier.
My lord,
And my lord has decided a similar issue, my lord.
already, and in that matter, my lord has put in a cost of rupees 2 lakhs on the writ petitioner for filing frivolous writ petition, and that cost was gone to the in favor of the whistleblower in that matter.
Yes, or is a similar type of matter.
My lord, similar,
That
similar,
type of
my lord.
matter.
Then it has to be hard.
Yes, my lord.
Sorry.
In this matter, I am for the petitioner.
My lord, I am for the respondent number 3 to 6.
Now, my lord, here, initially your lordship was pleased to pass an order on 25th June 2025. On that date, your lordship was pleased to direct them to file.
Give me a second, sir. Which was the respondent number 3 and 4?
My lord, 3 to 6, I am appealing.
On the last occasion, who appeared?
I am led by Mr. Pan.
So where is your report?
Now, my lord, that I am submitting that your lordship on 23rd was granted them for 3 weeks' time. Only yesterday they have subbed, and in the report also they have asked for liberty to file comprehensive affidavit in opposition. Now, my lord, I am asking Mr. Pan whether his client will file comprehensive affidavit in opposition or not. If he wants to file, let him file. I want to give reply to both in a comprehensive manner. Or if he choose not to file, then I shall deal with this.
Now, my lord, I tell your lordship why I intend to file the, my lord, the comprehensive affidavit in opposition. But the issue involved in this has been decided, has been settled up to Supreme Court. Now the relief
In opposition? No.
my lord, that is the reason, my lord, I like to
Yes.
file
Let him make that submission. I shall make appropriate submission at the relevant
Then
point.
why are you filing the report? You file.
My lord, this has been filed, my lord, subject in compliance of your lawsuit direction, because I am duty bound to file it. Since there is a direction upon me to file it, my lord, I am duty bound to file it. So that's why in the report I have sought for leave to file my opposition.
Yes, paragraph 11.
So I am praying your lordship kind leave to file my opposition in this, my lord.
Ashok.
I will file it as
behalf
the
of the
shortest
respondent
possible
number,
time.
on behalf of the respondent number 6,
You know.
I'm appealing for the statement.
My lord, I am for the petitioner. my lord.
Lakhon Mondol.
Yes, my lord.
Yes.
My lord, this is the third round of litigation, my lord. Wherein, my lord, the first writ petition was filed by the writ petitioner, my lord, who has been implicated as respondent number 8 hearing.
Is there any private respondent?
Yes, my lord.
What is the affidavit of service?
My lord, I have already served, my lord, I have already served upon all of the respondents, my lord.
So what is the affidavit of service?
My lord, the affidavit of service, my lord, the copies are here, my lord. I shall file it within the course of the day.
No, no,
My lord, the
not today, not today.
copies are ready, my lord.
Sir, we maintain some system. You have to maintain the system. What is the predicament making the affidavit of service ready?
My lord, within the course of the day, my lord, I shall.
I say no, sir. It will not be permitted. Come with the affidavit of service and I shall consider.
Grateful. My lord, in that case, my lord, the matters will appear, my lord.
Not today means?
Not today.
Am I to explain that?
No, no, my lord. Grateful.
You are a senior member of the bar.
No, grateful.
Service upon the private respondent has been affected.
Yes, my lord. That copies have already been, my lord, I have submitted at the time.
Come with the affidavit of service, sir.
Loading in the postal part. They are,
Yes, we are
we are
suffering.
not getting properly. আরে ওই যে কি সিস্টেম সার্ভারে চেঞ্জ করেছে না পোস্টে ওটা একটা প্রবলেম হচ্ছে
I am appealing for the respondent was 16 and
I'm for the
17.
petitioner, my lord.
আমাদের স্টেট
Give me a second, Mr. Chatterjee. You are appearing, sir?
16 and 17, private respondent.
What is your affidavit of service, Mr. Chatterjee? Service, you are for the state.
all are appealing.
This can be.
All have been served.
Hi. Up here for the private respondent.
It can be disposed of
18,
with a
19.
direction upon them.
I want to know.
Wait. What are you saying?
The original instruction was to take an adjournment on the ground of my senior Malak. He's not present in court.
No, he is appearing.
No, I am for 16 and 17.
You are appearing for
18, 19.
18 to 18 and 19. Chiranjit Sarkar and Pradeep Sarkar.
Yeah, perhaps.
Chiranjit and Pradeep service has been affected. What is your case?
My case is, my lord, I made a representation that PWD's land has been encroached by the private respondents, and that is virtually creating impediment for my in-res egress.
Where is the
121, 120 onwards. This is the representation.
No. Where is your pleading to that effect?
Yes, my lord. Kindly come to paragraph number. Paragraph number 11. The private respondents are doing the illegal construction over the land and water body in Dag number 287, 703 as well as the PWD road. The said building constructions over the road are causes blocking in front position of the shop rooms as well as the illegal construction, and hereby have allowed the government road to be encroached, thereby causing ingress and egress of the petitioners adversely affected. Virtually, the petitioners could not access their property to run the business. Not only those millions of people, travelers over the road, one of the busiest road of 24
Very good, sir.
kilometers.
Very good. Which are the relevant pages according to you?
Well, the relevant page is 119 onwards. This is the representation.
Page number, page number?
119 onwards.
19.
119.
119.
119. Whether this is the detailed representations I made before various authorities. Whether this is representation for the prayer of demolition of the illegal encroachment of Ramganga PWD road connects from Dharmotola to Ramganga road. Whether
Mr.
this-
Chatterjee,
Hmm.
who is the advocate on record?
Dipankar, my lord. Dipankar Das.
How long you are practicing, sir? How many? 1 year. What's your good name? Mr. Das, be careful when you file a paper before a court. এটা একটু বললাম ম্যাডাম মিস্টার উনাকে দেখাও
May I?
ওয়েট স্যার ওয়েট একটু ওকে দেখান কাইন্ডলি সি দি folded page. Don't file any paper which which contains any marking.
Oh, my lord,
Perhaps,
this was
but
filed wrongly
in another
number
court,
20.
Justice Rai released the matter. My
No,
lord.
my lord, this was
Might be some marking because I raised the point that it should be under the land.
yes.
Very good.
Determination issue.
Well, this can be disposed of with a direction to dispose it with it in a time bound manner.
কে করবে? কে করবে? দু তিনটে চেয়েছিস জল সব কিছু দিয়েছিস।
Is there a report, sir?
No, my lord, but one thing is that your lordship would kindly take up page 56 onwards. But the private respondents have filed a suit on the same plot of land as an injunction pending. That is regarding 6 decimals and this is regarding 2 decimals. Same. Page 60 would be relevant because the plot number is there. Your lordship kindly sees
And there is an injunction.
LR DAG number 287/704. Your lordship kindly sees?
See the upper portion, the prayer portion of the injunction application.
Yes. Your lordship is pointing out the schedule.
Prayer portion. Above the schedule. Come to the latter page of 59.
Hence, it is prayed that you.
No, Mr. Chatterjee. Let him read.
Hence, it is prayed the honor would be received please to pass an order of temporary injunction restricting the defendant and his men and agents, officials, associates from disturbing the peaceful possession user and enjoyment of the suit property by the plaintiffs. Here, the plaintiffs are the private respondents, and from encroaching the portion of the suit property from south or eastern southern portion and or take forcible possession of the suit property and.
Where the plaintiffs?
1670.
So here the allegation is different. Here the allegations are different.
Encroachment. Both are encroachment.
No, but
It will be removed.
no. One thing may I submit? Your lordship kindly turn page
During the pendency of the injunction order.
page 96.
So what is the suit for?
No. That is
Suit
different.
for declaration injunction. With the allegation against him that they are creating a disturbance with their property.
Absolutely. But
Now they have come forward with an application that the construction is made in such a manner, encroaching the PWD road, causing serious obstruction with regard to the egress and ingress.
there are not only on
The
land,
cause of
there are also
cause of action
water
are
body.
different.
There are also complaint about the water body. Now land, water body. Now
So whatever you like.
But the one thing your lordship kindly see that there is a proceeding under section 147 of the CRPC as initiated by the petitioner. And kindly come page 96 and 97, 96 and 98, that this land what possessing 16 and 17 respond are the Bastu land. So we are not encroaching, no injury.
May
Page-
be decided.
Page 96 and 98. These are the documents relied by the petitioner, so I am
Let
referring.
it be decided by the
May I
authority.
make one submission?
Make your
Your
submission.
friends have concluded. But my point is on a slightly different note. I'm not hiding behind the suit that is there, my lord, that has been filed. My contention is today, if your lordship passes an order directing, my lord, for the representation which is being preferred by the petitioners, alleging unauthorized and unauthorized encroachment to be disposed of. Effectively, my lord, your lordship is passing an order on merits. That's not simplicity or an order of, my lord, remand, because there are judgments, my lord. There's a judgment passed by Justice Bhaskar Bhattacharya. There are several, my lord, that even a remand order for representation to be disposed of, the court would naturally have to apply its mind.
I will not pass any order of
No, I'm
demand.
not
You
saying,
listen to my order.
Lordship will bear with, I haven't made the submission. Lordship, bear with for 30 more seconds, my lord. Then your lordship, I will not stand in them. Today, my principal allegation is the petitioners could not have filed the 226 because they've come with unclean hands. I want to bring, my lord, two documents on record which will show that they are the ones who are encroaching upon the Noyon Julie.
Absolutely.
There is a paper, my lord, I'm carrying. I don't want to, my lord, off the cuff hand it to court. I want to bring it by way of an affidavit, my lord. Lordship, that's a marked copy. I don't want to do that, my lord.
I will ignore that much.
The shortest possible time, their name appears, my lord. They have made an unauthorized construction, my lord, on Shali Jomi. There is a Bastu structure that they built on a Shali Jomi. Well, I want to bring this on record. If I can show this and if I can satisfy,
Give it to me. I want to see.
then, my lord, their writ petition would have to be dismissed. Now, I want to explain this by way of an affidavit, my lord. Lordship will not take my word for it. I want to bring that by way of an affidavit where I
Very good. You listen to my order.
And kindly record that a
The
proceeding on
petitioner-
47 is initiated.
May I take
The
your
writ-
lordship's kind leave? my lord?
Yes, yes. The writ petitioner
paper. That's the only
Hello.
copy I have.
Well, one thing I may pray, after hearing the copy of the order passed by the respondent number 7 may be handed over. Otherwise,
ভেরি গুড স্যার। আর একটা অ্যাড করে নিন, আমি ওটা সাজিয়ে দেবো। ওই একবার ফাইলটা দিন তো। ওই যে বললাম না, ওই যে পাশের রিসিভড অর্ডার, ওই যে কি বলেছে ওই জায়গাটা পড়ুন তো, ওই জায়গাটা জাস্ট বলুন, ওখানে অ্যাড করে দেবে। Be tech savvy. Yes, return it.
Grateful.
Number 12. 12. I am for the petition. Stated क्या चलो petition.
Any private respondent, Mr. Maiti?
No.
Who is for the state?
Just have the notice.
Very muskil. Very unfortunate state of affairs is going on. Have you served?
Yes, yes. Very short matter.
Sir, long, short, whatever may be, but state is to be represented, no?
That's true. Apart from that, I've challenged the order passed by the state authority.
Which order is under challenge, sir?
This is
Page number?
This is last annexure, page 35 onwards. Passed by the additional district magistrate. This has been done, my lord, the pursuant to the order passed by the Honorable High Court, page 30.
The affidavit of service as filed on behalf of the writ petitioner is taken on record. Yeah, it will happen. It will, I'm reaching there.
So that I can get the chance.
If I remain alive, sir, you will get a chance. That much I can say. Under the heading fees motion বলেছি তো under the same heading করবেন under the heading fees motion করে দিন under the heading fees motion
For KMD lordship.
item number 13
13. I appear for respondent number 6.
for private respondent sir Mr. Banerjee is for state and Mr. Talukdar for KMD. Give me a second, sir. Give me a second, sir. Wait, sir, wait. Yes, place your case, sir.
Ticket. Under
Act 2 of 1948.
The part payment was made in respect of the portion of the land. The remaining unutilized land, not still there, not so, no, since all the other those acts are is no more in the
So you want to get relief under 2013 Act?
2013 Act, and the unutilized lands, since the project has been completed, it is still being unutilized. It is to be delivered.
So place your case.
That is the prayer made in the representation in document 5, the page 45.
Page number 45.
Yeah, reply also. The relevant note.
So let them consider.
My lord, here I have it. My lord,
No, then wait. Then apart from page number 45, what document you have got?
The RTI reply, page 50.
Page number 45 is your representation. Then
And with RTI not reply to the RTI what they have stated not. The application has been admitted not. Award was passed on ad hoc basis.
just a minute, sir. So what? How does it helpful to you?
Because of the fact total amount 75 cutters of land were utilized. It was one cutter of land was given to each of the evicted person. What?
No, apart from these documents, what document you have?
Nothing. Only the prayer was made. It has not been considered as the. That's why the reputation is being filed.
if he has finished, my lord. My lord, first of all, my lord, I question the maintainability. This is not only belated, suffers inordinate delay, but also the claims are misconceived. If your lordship sees some averments made in the writ petition. My lord, here in paragraph 2, though it has not been made clear how much land and the original owner held and possessed. Paragraph 3, lordship will find this petitioner admits to have received the requisition order in 1975-76. It's a requisition of 1975-76. The next page, Lordship, the top.
From his submission, I do not know who is the
My lord,
petitioner.
what I understood, my lord, I try to satisfy your lordship. Then, lordship, this paragraph 3, last portion, lordship will find he admits that requisition order notices was served. It's an order, not notice. Then kindly come to paragraph 4. There he says that original LAK 67 was subdivided into four LA cases. Then 80% compensation he has received. This is requirement of law under Act 2, that the moment requisition order is issued, 80% compensation towards the cost of acquisition is to be deposited with the collector. That was done. He admits. That shows his knowledge right from 75-76. Instead of that, my lord, he claims that no award was passed. So he claims, my lord, the enhanced compensation. Here also in some other paragraphs, my lord, in paragraph, particularly in paragraph 12, that no section 3A or 3B was served.
Final award was not declared.
Now, lordship, kindly come to the documents which was given to him under RTI reply. Page 27.
Page 27.
Yes. If your lordships, these are the copies of the award he sought for. Now, lordship, before considering this, for a moment, lordship, kindly come to page 45 of his representation. Though it can't be treated as representation, it's an advocate notice. My lord knows.
That has it.
Page 45. 45 subject. I'll be referring, it would be convenient to understand, my lord. Subject, prayer for payment of compensation in respect of acquisition of property at HMC, premises number 21, 23 and 28. Brojonath Lahiri Lane. My lord, got it? I will not trouble your lordship much more. Now, lordship, kindly come to the documents which I, my lord, referred to at page 27, which was supplied by the government to the petitioner. First, lordship, kindly come to page 28. This is LA case number 67/8, perhaps 8. And the premises number, lordship, will find 20, holding number 28, Brojonath Lane.
Where from will get the LA case number?
LA case number at the top. At the top. Because it is contended by the petitioner himself in paragraph 4 that original 67 was subdivided into four LA cases. So this is 67/8 is one of them, which is in respect of 28 Brojonath Lane. In his representation, my lord has seen that in respect of 3 premises he claims, his claim is. So this is an award in respect of 28 Brojonath Lahiri Lane. The copy supplied. And now, lordship, turn to page 29.
Proceeding under section 11.
Yes.
In a proceeding under section 11.
It's under section, my lord, under Act 2. So award was, my lord, in the format used. Even if award is passed under section 7 of the Act 2, the format is used as section 11 format. This is the format.
It is the final award.
Final award. Now, lordship, next page, lordship will find that Kalpana Shandal name is appearing just, my lord, at the middle of the page.
Page number?
20. Next page, 29.
Money paid.
Sir, wait. You got your chance.
So Kalpana Shandal's name is appearing. Right hand side, lordship, will find the several stamps are there, which, my lord, denotes, my lord, regarding payment of compensation amount. Just right hand side of Kalpana Shandal,
Lordship, kindly take the stamp paid by so and so, check number so and so, 18/8/1992, when the act was alive. Act 2 was alive. Next, Lordship, kindly turn to page 31.
Kalpana is a party.
Kalpana, I'm referring
number
to
one.
this. I'm referring to one of
The
the
number
31. At the top, left-hand side top, Lordship will find 67/9. My lord, got it? At the top. This is not so much legible.
case number.
Case number. LA case number 67/9. This is another.
Holding number 23 Bojanath Lane.
23 Bojanath Lane. So my lord has got 28 Bojanath Lane, then 23 Bojanath Lane. Lordship, kindly turn to page 33. Again, Lordship will get the name of Kalpana. Again, at the middle, Lordship will get the, at page 33, name of the Kalpana. And right-hand side stamps shows that payments were received on 18/8/1992 by some, through advocate. Lordship will find all these stamps contain the citation, my lord, that through advocate, 18/8/1992.
সবই তো পেয়ে গেছি তাহলে।
Yes. Then your lordship kindly turn to the one premises remain according to the representation. 23, 28, my lord has seen. Now lordship kindly turn to page 35.
21.
This is 21. So all these three in the representation he prays for. And that too, this is one part. And page 36, lordship again, Kalpana's name will lordship will find left-hand side at the bottom. Right-hand side stamps are there. All are the same date, 18/8/92, received through advocate. So in respect of all these three premises,
What has been
AOT
declared
has
and
received
payment has been disbursed.
compensation on 18/8/1992, much before the
Why he is
act.
claiming now?
That's why in my I started with the saying, my lord, this petition is totally misconceived. And at this belated stage, my lord, when he admits the receipt of requisition order in 1975-76, had the petitioner any grievance, they could have resorted to, my lord, reference and all this. Under Act 2, there is also provision for reference. If they were not satisfied, if there is any surplus land which was not utilized but occupied by the government, even in that, my lord, situation also, it is too late for them to approach the court and to seek a direction, seek a mandamus directing the government to do something. After 50 years, if someone comes and says the government has done in 75, now give me the relief, whether that is permissible. My lord knows that Digambar's case is the answer on that, where 20 years was not condoned. After 20 years, that petitioner had come and so no, it was held, my lord, it is not possible for the government to keep all those records to prove that the action was done by so and so manner. So all on a sudden, after all these years, the petitioner has come up with a purported story. So in my respectful submission, my lord, this petition cannot be entertained.
let him come forward with a document that the
No,
final award has
they have not stated about.
What remains? What?
Project was continuing after the completion of the project. It came to light that some portion of the acquisition portion remained unutilized. That's why not the
The
pair was.
petitioner has suppressed
But
that
then
after
ample
80% compensation, possession was taken and the rest of the amount was calculated and paid to them. That part they have not conveniently suppressed.
After this,
We have the documents to show. I have the instruction also.
Milord-
Initially 80% compensation, possession. After that, Milord, rest was calculated. There were 4 cases. In one case, it was converted to Act 1. In the other cases, Milord, in 1992, it was calculated and paid. An award was prepared, what not I find. Now, even if not, they say that the award was not in accordance with law in 1992. They received the entire money, the balance money. They did not challenge. Now, after from
Where is
1990,
that document that they paid?
that is my instruction, Milord. I can file an affidavit stating that, but they have suppressed. এটা আমার ইনস্ট্রাকশন আমি তো ওনাকে পাশে দিতে পারবো না অ্যাফিডেভিট করে দেবো অ্যাফিডেভিট করে দেবো lottery will similar 4 cases were prepared initial the first one is regarding holding number 26 and 27 kindly comes to page 2 the 4 cases have been described holding 26 27 converted 93A they are not asking for it and 28 21 and 23
they are asking for
these 3 premises
21, 23, and
similar
20.
balance was paid to them. They have received it. This part has been suppressed by them. কে আছে পিটিশনার নামগুলো মেনে নিতে পাওয়া যাবে
ওই যেটা কনভার্টেড হয়েছে হি ইজ নট কোশ্চেনিং দ্যাট
না হি ইজ নট কোয়েশ্চেনিং দ্যাট সবাই তাই সংগ্রামিত্র ভাদুরী ভট্টাচার্য শুভব্রত ভাদুরী না ওরা বলছে যে এই 3টে কনভার্ট হয়নি কিন্তু ফুল পেমেন্ট তো হয়ে গেছে
These are the awards. How he is relying on these awards. How can it deny?
The allegation of non-payment of compensation is not correct. Twenty-seven, Sovita Brota, Brota, Kalpana Shannar. Pune Expressway, Pune Express. In the 21, 23. Yeah. Line of that emergency acquisition যদি হয় Section 17 Land Acquisition Act. Possession taken, compensation paid, or compensation. তাহলে vesting will not be, so vesting will remain.
এখানে একটুতে তো বেস্টিং
vesting হয়ে যাচ্ছে
Hello.
এই একটা জায়গায়
Give it.
My lord, while recording my submission in one place, I have been indicated as instead of Talukdar Sandal has gone down.
Oh,
And
man.
in one place, Sandal has gone down.
Sorry.
Both are
My lord, I appeal for respondent number 1 and 2, my lord.
For the
14.
petitioner, my lord, Mr. Orkodet is appearing for this matter, my lord. I have been informed that he's court number 11, my lord. So kindly keeps it after 2 p.m., my lord.
Not today.
Obliged, my lord.
Number 15.
15 who is appearing. The parties are not represented. এটা দিন পে করে নেবো, ফাইলটা দিন এনে এসছেন, ওটা কেটে দিন, এসে গেছে। 14 15 এটা 14 ডাকলেন 15 ডাকলেন? ও,
The matter for
give me a second.
payment of compensation, my lord.
Give me a second, sir. Yes.
Payment of compensation, I made a representation on page number 46, my lord. Payment has to be paid as per the new act, my lord, 2013 act.
Page number?
Page number 46.
46?
46.
Oshit Mondal?
Oshit Mondal, my lord. Well, there are number of petitioners, my lord. My lord, there are number of representation. I have annexed all of it.
It's like yesterday's matter.
No, this is a first round of litigation, my lord. I made representation to the authority. Authority did not consider it. For consideration of the representation.
Page number 46 or 47?
46, 47, 46 to
56.
ওগুলো ওকে দিনে পেজ মিলছে না।
56. Okay, so
এটা প্রেয়ারই তো বলতো, প্রেয়ারই তো বলতো।
Kindly check, kindly check.
Forty-seven. 47 to 50.
47.
So what do you undo? Consideration?
Yes. Land of poison was taken. Till today, no compensation was paid.
47 onwards.
47.
Why all have been added?
Yes.
Mr. Bhattacharya, I will not accept your writ petition in court. You have to file separate writ petitions.
Well, if I could have put that stamp, my lord, I can do it, my lord. No, I have not. By this week, by
How many writ petitions will be considered?
first,
How many prayers will be considered by them?
the same case, my lord. Similar, that is why you also can see the prayer also. Leave was also sought for. Only for my lord. Leave may be granted. Prayer A. Stamp দিয়ে দেবো।
আসুন আসুন আসুন। At the very পড়ছে না ভগবান জানে।
First aged.
আগে age
Now,
পরে
after,
now.
now it has been
Oh.
meant the first gift and the
Previously it
age.
was
Thereafter,
previously it was the other way
exactly,
around.
yours are name, then son
Oh,
or wife.
Aged about then there is son.
First aged about the
oh,
what
I'm
the age.
sorry. I'm sorry. I'm sorry. I'm
Now
sorry.
it has been, we have to mention the age also.
এখন তো মোবাইল নাম্বারও দিতে হয়।
Mobile number দিতে হয়।
Names are not matching.
As regards the Ille case is concerned, the awardee has been
Case
listed.
whether they
Yes, yes.
they are the land losers under the self-selfless, then why their names are not matching?
এদের কাছে অনেক আছে, অনেক ল্যান্ড ইউজার।
না না এইটার বিয়েতে এটাই
আরে ইন দ্য
তুমি যেটা
ইন্ডিয়া
দিয়েছো।
এদের কাছে বলা যায় সো মেনি ল্যান্ড ইউজার।
আরে যার যেটা আছে তার নিচে প্লটটা
একটা প্লট অনেক আছে।
কি লিখলাম বলুন তো?
But Mr. Pan also is every day is doing it. And already this affidavit service that is from my
No, apart from
Mr. Pan has that was transferred by Mr. Pan. But this is my affidavit.
is there any private respondent, Mr. Ghosh?
No, not this supplementary. There is
I am for West Bengal hit code 326. 326 তো কত? হ্যাঁ 326 আপনি 326 আছেন।
You are for this, sir?
West Bengal hit code 3 to respondent 3 to 6. And I'm 1, 2 and 7.
3 to 6.
Yes, 1, 2 and 7.
You are for?
1, 2 and 7.
Yes, Mr. Ghosh.
But the admittedly property
Adjust the microphone.
Lord, admittedly property originally belonged to my father. My father bestowed this property in my favor, and blood record of right also prepared in my name. Lord, then I filed a
Your
civil.
father gifted the property to you
Yes, this document is annexed with my report.
prior to acquisition or post acquisition or prior to acquisition?
Lord, that is in the year. I'm giving the date. Lord. Deed of sale. Lord, in 1996.
Then what happened?
Then, Lord, I filed a civil suit against the private individual who is not admittedly party over here. Lord, I obtained an order of injunction. The order of injunction was subsisting over this property. One fine morning, Lord, my position was taken over by the.
The order of injunction is in personam, not in rem.
Not in rem. Lord, then in Lord, the order during subsistence of the order of injunction, position was taken over by the state respondent. Then, Lord, a client came to my chamber. Then it is my personal exercise. Lord, they kindly come to page 39.
Communication between you and your client is a privileged communication. Why are you disclosing that?
Lord, kindly come to page 39 from the official website of the state respondent. I received this page 39 and 40. Lord, page 40, serial number 1898.
Yes.
My Lord, got it. 1898 serial number. That is the Lord, the concerned plot that was acquired in the on 30th June 2008.
3956.
3956.
It was acquired on 13th June
2008. Now, Lord, my contention before your Lordship is this: neither I nor my father receive any compensation from the state authority. Lord, if the state wants my land, he has to pay the compensation. He has not paid the compensation. I filed the representations. Lord, I pleaded in my petition regarding my representations, but I could not annex the representation with my petition. That was lacuna on the part on my part. That is why, Lord, I have undertaken to file a supplementary affidavit. And Lord, there is a mistake. I tender apology for that. Signature of the client is not there at page, sir.
Page?
Signature of the client is not appearing, but it was sent by the speed post. And
without signature?
No, Lord, with signature. The office copy I have annexed, but all the postal receipts, track
It
report.
does not have any value. If you take it back, never happen. So what is your grievance?
Lord, if the state wants my land, he has to pay the compensation. The compensation has not paid. Or restoration of possession in absence of the compensations.
Yes, what have you got to say?
Lordships, in this matter, I am appearing for the HITCO Lordships. Paragraph 12 of the writ application, page 7. Admitted position is the petitioners on 1st of July 2020, the petitioners came to know from a reliable source that the taking over the possession of the property, the HITCO published a notice such and such website, and the property has been acquired in connection with LA case number Rato, and possession was taken on 13 of June 2008. Long back of before filing this application. If they are not entitled, if they have not received the compensation, Lordship, the compensation, certainly the LA collector will not go to his house. Let him approach to the LA collector. They have did not any compensation. Kindly allow me to take the compensation. Matter will be finished.
You have not made the LA collector as a
LA
party.
collector is not a party. Neither the special land acquisition officer is a party.
Mr. Ghosh, your application is defective.
Let him approach me.
Lord, I crave leave of the Lordship to add the LA collector.
Yeah, otherwise, Lordship, the matter will never be solved, Lordship. If the LA collector be not added as party, Lordship.
LA collector South 24 Pargana?
Not 24
Not
Pargana.
Huh?
Not 24.
Not 24 Pargana. Barashat, head office.
Neither the representation, I believe the representation was also not sent to the LA collector.
It's given to the learned advocate.
Number 17. HON'BLE. The report file good. Report file good.
Yes, Mr. Pan. Any private respondent?
There is no private respondent, my lord.
Who is for the state?
We both are for the state one.
No, my lord. Proceeding was initiated under the, my lord, the West Bengal Fisheries Requisition and Acquisition 1965. Now, possession was taken over by way of requisition. Now, my lord, that was the agricultural land. Now, subsequently, my lord, they issued a notification under Section 7 for derequisition of the property. Act says the moment derequisition is being made, collector has to return back the possession. If you also kindly turn to Section 7(1).
I don't have the book.
I am handing over to you, Roshi. It is just a thing. Where any fishery of or land requisition under Section 4 are not acquired and are to be released from the requisition, the state government may, after making such inquiry, if any, as it consider necessary, specify by an order in writing to the person who appears to be entitled to the possession of such fishery or land. The delivery of such delivery of possession of such fishery or lands to the person specified in the order made under subsection 1 shall be a full discharge of any liability to the state government. Now, let's kindly turn to the notification once.
Shall be a full discharge of liability to deliver poison to such person.
At page 27.
What is page 27?
Yes, this is the notification under Section 7(1).
Page 27.
Serial number 2. Under serial number 2. Schedule number 2, my lord. At column number 4, your lordship will find in the third line, plot number 423.
Just a minute, sir. Yes. Now, in excess of the power conferred by subsection 7(1), and the governor is pleased to release such land as described in the schedule from the requisition. Yes. Schedule, sir. Which portion?
Schedule, my lord, serial number 2.
Yes.
Then, my lord, kindly turn to column number 4.
Yes, sir.
Third line, 423. That is the subject matter of this writ petition. Then, my lord, lordship, kindly once again turn to the act itself.
Yes, sir.
The delivery of possession, subsection 2, of such fishery or lands to the person specified in the order made under subsection 1 shall be full discharge of any liability of the state government to deliver possession to such person as may have rightful claim to possession thereof, but shall not prejudice any right in respect of such fishery or lands which any other person may be entitled to by due process of law to enforce against the person to whom possession of the fishery or lands is to be delivered. Next, where the person to whom the possession of any fishery or land requisition under section 4 is to be delivered cannot be found or is not readily traceable or has no agent or other person empowered to accept delivery on his behalf, or such person or his agent refuse to accept such delivery, the state government shall publish in the official gazette a notice declaring that such fishery or lands are released from requisition and shall cause a copy thereof to be affixed on some conspicuous part of such fishery or lands as the case may be. My respectful submission before your lordship is this, my lord. The stage of section 3 has not come because there is no notification. So thereby they cannot say that I refuse to take over the possession or any other reason which subsection 3 attracts. There is no such notification as of date. So therefore, my lord, the collector is due to bound.
Delivery of possession of such fishery to the person specified in the order.
Yes.
But then has it been specified to whom it will be delivered?
Well, that is the order entitled to. That's why, my lord, because the collector has to inquire. That is the inquiry that is to be made by the collector. Then, my lord, kindly see, my lord, I drew the attention of the collector. Next page, page 29.
Page 29.
Indicating everything.
Who is the writ petitioner here?
Lord, I am the Arun Kedia. I purchased this land.
During requisition? During requisition?
During requisition, I can. Because property does not vest with the state. The title remains with the person concerned. Until and unless this is vested with the state, then my right title interest remain with the landowner. This is akin to, my lord, the provisions of land acquisition cases. Kindly turn to, my lord, for your satisfaction. Your lordship kindly, if your lordship kindly turn to section 5. Here everything will be clear. Section 5, subsection 2. There should be a notification under section 4. The moment this is published under subsection 2 of section 4, then property vested with the state from free for all encumbrances. Then I cannot transfer. So until and unless there is a notification under section 5, title remain.
What is your grievance? Non-consideration of your representation.
My grievance is non-consideration in the other way, my lord. Here the collector is duty bound to hand over the possession to me. Since I drew the attention of the collector.
He will take a decision.
My lord.
He will take a decision.
My lord, my lord.
Because 66 it was, my lord, taken up. And thereafter the transfer is, he is the third transferee perhaps. He purchased it 2007 during requisition. Let that decision be taken by the collector.
Yes, yes. No. Can you direct a time-bound program, my lord?
Paragraph 3, your lordship will see the chronological right.
The affidavit of service has filed today on behalf of the writ petitioner is taken on record. Stop para. By filing the instant writ petition, the writ petitioner has paid for issuance of appropriate writ or writs against the respondent authorities. More specifically against the respondent of 3 authority, commanding him to release the derequisitioned land, particulars of which has been mentioned 15 or 19?
19th February 2015.
2015.
officials about my file released by your lordship, and also for the affidavit submitted on that day. But they told me ki judge জিজ্ঞেস করবে জজ সাহেবকে বলো আমাদের সঙ্গে কথা বলার দরকার নেই।
কি করতে হবে আমার?
লর্ডশিপ, আমি ওটা এফিডেভিটের যে কপি, যেটা অরিজিনাল কপি ছিল, সেটা আমি দিয়েছিলাম এখানে। আর ফাইলটা কোথায় আছে সেটা তো ইনারাই বলবেন না স্যার, এফিডেভিটের কপিটা কোথায় গেল?
Gap, my lord, he has mentioned before your lordship on my ground. That is, I told him that you kindly mention that matter before his lordship.
After vacation, I will take up.
Yes. Otherwise, impression of the judge will be against you.
No, no. Oh,
Because there
it
is
may
a-
so happen. No?
some gap, my lord. That is the reason.
Mr. Banerjee, I know you for a pretty long time.
Lord, I know that, my lord.
And
I know that.
I had a long tenure at Howrah also.
Lordship.
So I know you very well. No chance of miscommunication and misunderstanding. That much I can assure you. It will be taken up after vacation.
Well, may I permit to mention even item number 32, that is also 2 PM fixed matter.
Now Mr. Banerjee's matter will be taken up. Thereafter, if time permits, other matters will be taken up.
My lord, that matter, my lord, my land.
This matter, that matter, I don't understand. Now I'll say Mr. Banerjee's matter will be taken up, which is a parted matter. Call the list, call the list.
No, I was paying for 15 minutes time. You know, the contempt matter is like 2 PM fixed matter. I'll come 15 minutes. I'll come back. I'll do the matter. I'm ready, my lord, fully ready.
So I'll sit idle.
No.
Then?
Next matter, my lord. Pass over.
No, this way, this fashion, I cannot do it.
Very well. Then, because the personal affairs of the principal secretary has been.
No, sir. I think.
I'm ready with.
দেখি ফাইল দিন ফাইল দিন। ওই ফাইলটা দিন, রিট পিটিশনটা দিন, রিট পিটিশনটা দিন, এইগুলো থাকবে। ভেরি গুড, প্লিজ স্টার্ট মিস্টার ব্যান। এদিকে দিন, এদিকে দিয়ে দিই, সব দিয়ে দিই।
I've indicated the points on the last occasion, my lord, on which I seek to challenge, my lord, the findings of the disciplinary authority as well as appellate authority. Trap program was conducted on the basis of a complex.
No need of recapitulation. I've gone through.
Right. Now, my lord, on the last day, I have submitted that the witnesses in both the proceedings are same. I'll show, my lord, that.
That portion you have not shown.
No, that I have not shown, my lord. I submitted, my lord. I placed the inquiry report to show that
some discrepancy
between two sets of witnesses. One set is not the witness employees of the WBSCDCL who are the members of the trap team. The other is not the police personnel who have prepared the seizure list. They are also member of the trap team, but they are, my lord, of the police who.
I have noted.
Was noted.
And you have also stated that the complainant was not examined.
Complaint.
And even then the written complaint was marked exhibit. You got no chance of cross-examination. All you have raised all that.
And not the cassette was also taken as an exhibit. The cassette recorder in which alleged conversation between the complainant and the accused was recorded, which is proved by none of them. I disputed. It was produced. I disputed, and not the complainant also didn't prove it. The other persons have proved it. So that was also recorded. Now, my lord, your lordship, on the last occasion, put a very pertinent question that regarding the evidence, the court cannot go into reappreciation of evidence. I submitted, I'll place the judgments. Not I submit not that it is not a absolute law that court cannot look into the evidence or reappreciate it. Only certain exceptional cases court can, where the finding is perverse. It can be seen that it is perverse, or where the findings arrived at, no reasonable man could have arrived at that. These are the only exceptions where the court can. But to see whether this case falls within that category or not, but I can show selected portions to show the discrepancy and the perversity. It is not that court cannot look into it. Court will not reappreciate. So I can place certain portions, which I was doing on the last day, my lord. So it is not the law that court cannot look into it at all, because otherwise how the court will know whether there is perversity or not. So on that, my lord, I placed the two sets of witnesses. Now, my lord, one interesting thing, my lord, because I have said that the witnesses of the trap team, one set has said that they have gone inside, they have seen the charged officer with the money in his hand. And the police officer has said, the SI who has prepared the seizure list, he has said it was lying in the court, he was not holding it, or it was not with him. And the DW1, who is the independent witness of the lodge, he has also corroborated that, saying that he was not holding, they were saying hold it. The complainant, my lord, interestingly, in the criminal proceeding, my lord, a portion of his cross-examination was considered by the court, where the complainant is also not saying that it was given to his hand. It was kept in the court. Then the witnesses which have been, my lord, considered, my lord, and accepted by the inquiry officer, it completely falls apart. Because if the complainant doesn't say that I have given the money to his hand and he was holding it, in cross he says it was lying in the court. So the version of the police officer, my lord, which is contrary to the main prosecution case, my lord, that is corroborated by the evidence of the complainant.
Mr. Banerjee, how evidence of a criminal proceeding can be helpful to a concluded disciplinary proceeding?
So now I am before your lordship in judicial review. If I can show, my lord, the incongruity and, my lord, the perversity, because in the present proceeding also,
you can show the incongruity,
my lord,
provided same set of evidence was used.
Yes.
That you have to show.
I'll show that, because
Mr. X has stated before the disciplinary authority inquiry this, and Mr. Such and such, Mr. X has said before the trial court in this. Then you can succeed.
Lordship will kindly, my lord, take the supplementary affidavit which is filed by me.
Yes.
I shall keep it, my lord, with the inquiry report, so that I can show your lordship, my lord. Kindly comes, my lord. Page 91, which is the list of the prosecution witnesses. First is the, my lord, complainant.
Yes.
Then, my lord, Dulal Chandra Pal is the PW2 in both the cases. Your Lordship will not get that in the inquiry report at page 198 onwards. No, 9, তুমি কোনটা দেখছো? Supplementary affidavit. Nirobandhu Gora is the complainant. Dulal Chandra Pal is PW2 here also in the disciplinary proceeding.
Dulal Chandra Pal is the PW2 in the disciplinary proceeding.
Disciplinary proceeding.
And another?
Same Miller, who is the manager P&A.
Manager?
Mr. Pradeep Vishwas, who is the PW3 in the criminal case, he is PW7.
Yes.
Lordship will find it not in the inquiry report at PW7 to DSP.
Pradeep Vishwas is not PW7?
No, he is not, Millard. Because OSD Vigilance, he is senior manager OSD Vigilance. Sanjeev Kumar Datta is the executive magistrate, who is not also there in the proceeding. He is Millard, PW6. Sanjeev Kumar Datta.
PW4?
PW4.
PW4 is PW6 there?
PW6, yeah.
Very good.
Then Millard. Gautam Kumar Bakshi.
Do not make any homework before coming to court.
Devjit Sarkar Millard, PW6 is not assistant manager P&A, who is not here.
Not only I can say, my lord, against the judgment of criminal court, appeal was pending.
PW6, Devjit Sarkar is PW4 here, my lord, in the disciplinary proceeding.
PW4?
PW4. Then not PW8, Sanjay Chakraborty is SI, who is PW8 here also. PW8, Sanjay Chakraborty is PW8 in this proceeding. PW2 is manager P&A. PW1 is Millard, Pradeep Vishwas, senior manager. PW3 is PW1 here.
Yes.
So, Millard, 1, 2, 4, 6, 8. All these persons are, Millard, members of TRAP team who are the witnesses in the criminal case, apart from the complainant himself. So the police officer also, the maker of the seizure list, is also here, Millard, and all the other witnesses, PW1, 2, everybody is not, and the charge is, Millard, in the criminal case, same, Millard, under prevention of corruption, asking of bribe. Here also, the allegation is, charge sheet is that asking for and accepting bribe. Same allegation, and the incident is also the same trap program of which all these persons are members. So, Millard, same incidents, same set of witnesses, and same allegations. On the basis of this, Millard, the criminal court has given the verdict. I will just this I have already indicated to your lordship, Millard, the complainant Madhusudan Garai, he has said, which is recorded in the judgment. I'll just place one. 112. Kindly come to 112 once, Millard. Second paragraph.
Yes.
PW1 in its cross-examination dated 2nd June 2016 categorically testified that there is a cot kept on the left side of the said room, being number 11, immediately after entrance door. Immediately after entering into the room 11, I kept the said packet in one corner of the cot which was nearest to the entrance door. This was his admission in the cross-examination. Now, my lord, I shall not trouble your lordship with the findings, but I have also marked the findings because that will unnecessarily not waste your lordship's time. But page 20, internal page 26 of the judgment, 115 onwards, is the findings, categorical findings, which is not benefit of doubt, but specific finding that they have failed, miserably failed to prove their case, and it was a sort of conspiracy by a higher official, by Mr. D.K. Karok, who was the superintending engineer.
Mr. Banerjee, that is in a criminal proceeding.
Yes, yes. Criminal proceeding.
How do you correlate these depositions with the evidence that has been recorded in the inquiry proceeding? That I intend to know.
Now, my lord, then may I place not the set of judgments which says that if the criminal proceeding and the disciplinary proceeding are based on the same set of facts, same allegation and same witnesses are used to establish both the charges, in that case, in those cases, the findings of the criminal proceeding, if there is not benefit of doubt, but honorable acquittal, saying that the prosecution has failed to prove the case, in those cases, the accused person in the disciplinary proceeding shall get advantage of.
So show me the one or two judgments.
Mine.
Thereafter, we'll come back to this.
Mine. But first in the line is Miller, the 1999 judgment of M. Paul Anthony, reported at 1999, 99-3, Supreme Court cases 679.
99 volume 3 SCC 3
679.
679.
Yes. Six, seven, nine. Lordship will kindly come to paragraph 34.
Paragraph
34 of this judge. There is yet another reason for discarding the whole of the case of the respondents. As pointed out earlier, the criminal case as also the departmental proceedings were based on identical set of facts, namely the raid conducted at the appellant.
You are reading which portion, sir?
Paragraph 34. Yes. There is yet another reason for discarding the whole of the case of the respondents. As pointed out earlier, the criminal case as also the departmental proceedings were based on identical set of facts, namely the raid conducted at the appellant's residence and recovery of incriminating articles therefrom. The findings recorded by the inquiry officer, a copy of which has been placed before us, indicate that the charges framed against the appellant were sought to be proved by police officers and punch witnesses who had raided the house of the appellant and had effected recovery. They were the only witnesses examined by the inquiry officer, and the inquiry officer, relying upon their statements, came to the conclusion that the charges were established against the appellant. The same witnesses were examined in the criminal case, but the court, on a consideration of the entire evidence, came to the conclusion that no search was conducted, nor was any recovery made from the residence of the appellant. The whole case of the prosecution was thrown out, and the appellant was acquitted. In this situation, therefore, where the appellant is acquitted by a judicial pronouncement with the finding that the raid and recovery at the residence of the appellant were not proved, it would be unjust, unfair, and rather oppressive to allow the findings recorded at the ex parte departmental proceedings to stand. Since the facts and evidence in both the proceedings, namely the departmental proceedings and the criminal case, were the same, without there being any iota of difference, the distinction which is usually drawn as between the departmental proceedings and the criminal case on the basis of approach and burden of proof would not be applicable to the instant case. So, court has made a distinction, my lord, on the standard of proof in these special cases. Next judgment is, my lord, 2006, volume 5. So, the judgment of Lord G.M. Tang.
Just a minute, sir.
কোনটা এটা দিয়েছি না আমাকে এখানে সার্চ করতে এটা পরেরটা নোট করে নাও 5 নোট করে নাও
Yes, sir.
Now, my lord, the next judgment is my lord 2006, volume 5, Supreme Court cases 446, GM Tang versus State of Gujarat.
2006, volume 5, SCC 446.
446.
Relevant paragraph?
Paragraph, my lord. 30, 31.
30.
30, 30 and 31. The judgment relied on by the judgments relied on by the learned counsel appearing for the respondents are distinguishable on facts and on law. In this case, the departmental proceedings and the criminal case are based on identical and similar set of facts, and the charge in a departmental case against the appellant and the charge before the criminal court are one and the same. It is true that the nature of charge in the departmental proceedings and in the criminal case is grave. Nature of the case launched against the appellant on the basis of evidence and material collected against him during inquiry and investigation, and as reflected in the charge sheet, factors mentioned are one and the same. In other words, charges, evidence, witnesses, and circumstances are one and the same. In the present case, criminal and departmental proceedings have already noticed or granted on the same set of facts, namely raid conducted at the appellant's residence, recovery of articles therefrom. Investigating officer Mr. V.B. Raval and other departmental witnesses were the only witnesses examined by the inquiry officer, who by relying upon their statement came to the conclusion that the charges are established against the appellant. Same witnesses were examined in the criminal case. In the criminal case, on the examination, came to the conclusion that the prosecution has not proved the guilt alleged against the appellant beyond any reasonable doubt, and acquitted the appellant by its judicial pronouncement with the finding that the charge has not been proved. It is also to be noticed that the judicial pronouncement was made after a regular trial and on hot contest. Under these circumstances, it would be unjust and unfair and rather oppressive to allow the findings recorded in the departmental proceedings to stand. In our opinion, such facts and evidence in the departmental as well as criminal proceedings are the same without there being any iota of difference. The appellant should succeed. Distinction which is usually proved between departmental and criminal proceedings on the basis of the approach and burden of proof would not be applicable in the instant case, though the finding recorded in the domestic inquiry was found to be valid by the court below, when there was an honorable acquittal of the employee during the pendency of the proceedings challenging the dismissal. Same request to be taken note of. Decision in Paul Anthony case will apply. We therefore hold that the appeal filed by the appellant deserves to be allowed. So Paul Anthony has been followed here. You know, this is not only 2006, 2024 also same principle is followed. I'm just indicating that the 2024 judgment. These were 2024 volume 1 Supreme Court cases 175. So consistently it has been followed.
2024 1 SCC
175. Paragraph 12, and I'll just not indicate.
Paragraph 12 and?
Paragraph 12 and Millard. 30 to 32.
302 32.
302 33 because 33 is the not setting aside part. I'll place para 12 first, my lord. 12 30 থেকে 33. Para 12 my lord, it says, however, same principle, my lord, if the charges in the departmental inquiry and criminal court are identical or similar, if the evidence witnesses that circumstances are one and the same, then the matter acquires a different dimension. If the court in judicial review concludes that the acquittal in criminal proceeding was after full consideration of the prosecution evidence and that the prosecution miserably failed to prove the charge, the court in judicial review can grant redress in certain circumstances. Court will be entitled to exercise its discretion and grant relief. If it concludes that allowing the findings in the disciplinary proceeding to stand will be unjust, unfair, and oppressive, each case will turn on its own facts. The GM Tank and Lord, some other cases are relied on. I have placed GM Tank, the first case. Kindly come to para 30. Yeah, 30 million. We are additionally satisfied.
Prior to that, Mr. Banerjee, please come to paragraph number 8.2.
8.
8.2. 8, then 8.1, and then 8.2. Read 8.1 once.
8.1 is whether the dismissal of the appellant from service pursuant to departmental inquiry was justified. 8.2b, on the facts of the case, what is the effect of the acquittal ordered by the appellate judge in the criminal trial on the order of dismissal passed in the departmental inquiry?
That is the pertinent question.
Specific question framed, and I'm grateful one. Issue was specifically raised and decided.
Very good.
Then paragraph 12, and then kindly comes to paragraph 30, my lord, the final finding. We are additionally satisfied that in the teeth of the finding of the appellate judge, the disciplinary proceedings and the orders passed thereon cannot be allowed to stand. Charges were not just similar but identical, and the evidence, witnesses, and circumstances were all the same. This is a case where, in exercise of our discretion, we quash the orders of the disciplinary authority and the appellate authority, and as allowing them to stand will be unjust, unfair, and oppressive. This case is very similar to the situation that arose in GM Tank. Apart from the above, one of the aspects is to be noted. Inquiry officer's report makes a reference to the appellant passing time. So the factual issue I am not going into, Millard. 31 and 32 are factual, and 33 is the conclusion. So basically 30 is not the finding. 12 and 30. Now,
Mr. Banerjee, just a minute. Will you please show me the charge as framed by the trial court?
The trial court. Your Lordship, Lord, kindly take up page 94 and 95. The basis of the complaint, Lord, reveal what is the basis. Page 94, kindly allows me, Lord, I don't have the charge sheet, Lord, right now. Allegation in the complaint. What was the foundation of the criminal case? Page 94. Pursuant to his said letter, Dinobandhu Gora intimated Mr. Dural Chandra Pal, OSD Vigilance, that on 4/1/2003 at about 8 AM he would pay.
No, come to page number 96.
Evidence of prosecution witnesses.
Just above that paragraph.
This court framed charge against the accused person on 7/1 under section 7 of Prevention of Corruption Act, and the accused person pleaded his innocence and preferred trial.
Charge was 7 under section 7 of the Prevention of Corruption Act. You have brought the Prevention of Corruption.
I'll get a copy.
It is available here. Wait.
Complaint is the same, Lord. Complaint of Madhusudan got by the trust.
Very good. You place page number 94.
94, Lord, is the complaint.
Allegations in the those are very relevant. Page 94 and 96.
Dinabandhu Garai intimated Mr. Dulal Chandra Pal, Vigilance Corporate Cell of WBSCB, that on 4/1/2003 at about 8 a.m. he would pay rest of the amount, that is rupees 1,30,000 to Mr. Niyogi at this temporary residence at Sudha Lodge at Bakura town. Mr. Dinabandhu Garai also requested Mr. Pal to lay a trap to catch the accused person red-handed while accepting bribe from him on 4/1/2003. In accordance with the order of Secretary WBSCB, Mr. Pal arranged a trapping program at Bakura town with the help of local administration. Sri Sandeep Kumar Datta, the executive magistrate, Sodor Bakura, accompanied the team of officers of corporate vigilance cell.
So same allegation.
Same allegation, same complaint, same allegation. He was found on that day and time.
Section 7, offense relating to public servant being bribed.
Two bundles of 21,000 were accepted personally by the accused person at the said residence as bribe. Now, my lord, if your lordship kindly comes to page 118. Last line. Charge sheet of the charge sheet of
Page number
118, bottom. In the case in hand, this court has already observed 118.
Just a minute.
The supplementary affidavit.
118.
118.
Yes.
Last two lines. In the case in hand, this court has already observed that the prosecution has miserably failed to prove the factum of demand of gratification by the accused person and acceptance of gratification as contended by prosecution witnesses is not trustworthy in view of the discussion made herein above. Accordingly, there is no scope to draw presumption as enunciated under Section 20 of the Prevention of Corruption Act against the accused. For the aforementioned reasons, the decision relied upon by the said prosecution cannot be relied upon. Then will the role of Mr. I cannot, because this was not the case made out here. Although in reply I have said, Mr. D.K. Karok, who was the superior officer, who is instrumental, that has been discussed, my lord. I am not going into all this. In the finding at the end is, my lord. Finding of the court at page 122. Finding of the court. The term honorable acquittal was considered by the Honorable Apex Court in Deputy Inspector General of Police versus S. Samudrathiram. Through different pronouncements of Honorable Apex Court, it has become clear by referring the term honorably acquitted means accused is acquitted after full consideration of the prosecution case, and the prosecution miserably fails to prove the charges leveled against the accused person. Said expression also means acquitted of blame and fully exonerated. In the light of the discussion made herein above, in the absence of any cogent, convincing, and unimpeachable piece of evidence, there is no room of doubt that the prosecution has miserably failed to bring home the charge.
It's an honorable acquittal.
Honorable acquittal. Now, but I am not placing the charge. Place the charge sheet already to your lordship, my lord. The charge in the criminal case was that trap program. Charge sheet also is the same, my lord. Trap program. Same complaint.
Charge sheet I don't require. I require charge, but that is under Section 7.
Section
Based
7,
on the same
Section
facts.
7 on the same facts, and in the disciplinary proceeding. The
Probably I understand your contention. So when on the same set of facts, on the same written complaint, on the basis of the same charge, and on appreciation of the evidence of same witnesses, criminal court has given him an honorable acquittal. That must have been, there must be an what I would say, there must be an good effect upon the
court will consider not
favorable, there is a favorable effect in favor of the repetition.
My lord. That is one proposition, my lord. So for that I was not placing this, my lord, judgment, and in this judgment, but I have placed one paragraph, particular paragraph where the complainant has given his version in cross that he has entered the room and kept the money in the court. Because if not, there is violation of natural justice, or if there is the findings are not so perverse that no reasonable man can come to the conclusion, in those cases court can look into it.
I understand you.
Now, if the entire prosecution witness in the disciplinary proceeding, everybody say that he has gone inside and gave the money to him, he was holding the money.
No,
But the
that
main
is
person,
one thing. Mr. Banerjee, your first fold of submission was that the appreciation of evidence as made by the inquiry officer has been done in such a fashion that no reasonable person can come to a logical conclusion
on the same.
So, to that extent, the finding of the inquiry officer is perverse. There lies the perversity.
One, perversity. And on natural justice matter, I have already submitted that the complainant, on whose complaint the proceeding has been carried on, if that complainant doesn't come, then the complaint cannot be marked as exhibit and
that has been exhibited and that has been relied upon in the disciplinary.
heavily, because that is the complaint on the basis of which, because the allegation is
which causes a prejudice to the writ petitioner by way of denying principle of natural justice. So that can be reviewed in a disciplinary in a proceeding on 226.
Both natural justice and perversity, both elements are present in the present case.
And your third limb of submission is that on account of honorable acquittal in a criminal proceeding based on the self-same complaint, based on the self-same set of evidence, when the criminal court gives a honorable acquittal, it must have an advantageous effect
on the consideration of the.
I understand.
Because the Supreme Court in all such cases, after being convinced that the charges were same and the evidence was same, had not acquitted the person of the charges. And that is not the only case, that is a supporting case, because I have other cases I have already placed before Lordship, that natural justice. On that I have two judgments to place, my Lord.
Yes.
How a charge is to be proved, or documents are to be proved.
How a document is to be proved in a civil proceeding or a criminal trial or in a disciplinary proceeding?
In a disciplinary proceeding, my Lord. 25 SCC online. I have one hurdle. Last I'll come to that. There is a recent 2025 judgment which says that non-examination of complainant is not fatal. So I'll place that and I'll distinguish that judgment. That doesn't apply to this case. But before that, I'll place two more judgments, my Lord. 2025 SCC online, SC 89 note.
2025 SCC
online, Supreme Court 891. Not my copy আছে Lordship will kindly take up paragraph 14. That is the summarization of the legal position, my Lord. How a disciplinary proceeding, how documents are to be tendered. A document itself doesn't prove itself. Document has to be properly tendered by the person having knowledge over the document. Paragraph 14 of the judgment, my Lord.
Yes.
Just a second, I'll just. I have a copy in my phone only. Para 14 mein I place. What follows from a conjoint reading of the above two decisions is, and what applies here is that materials brought on record by the parties to which consideration in the inquiry ought to be confined mean only such materials can be considered which are brought on record in a manner known to law. Such materials can then be considered legal evidence which can be acted upon. Though the Indian Evidence Act 1872 is not strictly applicable to departmental inquiries, which are not judicial proceedings, nevertheless, the principles flowing therefrom can be applied in specific cases. Evidence tendered by witnesses must be recorded in the presence of the delinquent employee. He should be given opportunity to cross-examine the witnesses, and no document should be relied on by the prosecution without giving copy thereof to the delinquent. All these basic principles of fair play have their root in such act. In such light, the documents referred to in the list of documents forming part of the annexures to the charge sheet on which in the inquiry cannot be treated as legal evidence worthy of forming the basis of a finding of guilt if the contents of such documents are not spoken to by persons competent to speak about them. This is very important. A document does not prove itself. In the inquiry, therefore, the contents of the relied on document have to be proved by examining a witness having knowledge of the contents of such document and who can depose as regards its authenticity. In the present case, no such exercise was undertaken.
But it does not say that the document has to be proved by the author of the document.
It says, my lord, that the person competent to prove it, and who is competent to depose about its contents. Now, in this case, my lord, the OSD vigilance, he is proving the content. Is it permissible? Complainant is not present.
No, sir. If you please look once, a document does not prove itself.
Yes.
In the inquiry, therefore, the contents of the relied on documents have to be proved by examining a witness having knowledge of the contents of the document and who can depose as regards its authenticity.
Yes. Who can depose?
As regards its authenticity.
Yes, but the previous line, my lord.
A document does not prove
spoken to
itself.
by persons
In the
competent to speak
inquiry,
about.
therefore, the contents of the relied on documents have to be proved by examining a witness having knowledge of the contents of those document
Yes.
and who can depose as regards its authenticity.
But regarding the signature of the complainant, my lord, the persons who are the member of the trap team, the interested witness, can they be, my lord, competent to depose about it? They have said that we know him.
Where is the bar?
Because there's one more aspect in the same paragraph. The court has said, because if a document is brought, the witness who proves it or the author, he has to be cross-examined, because the complainant was not allowed to be cross-examined by me, and their entire case is that I have prevented him from appearing. I'll show me not these specific portions in the inquiry report and the disciplinary authorities order.
You come to page number 198, sir.
198.
Internal page number 3 of the written complaint.
Yes.
Read the second paragraph.
He is the senior manager who was attached to the corporate vigilance cell during the period 96 to 2003.
Yes.
He gave out the prosecution case. He stated inter alia the complaint of Dinobandhu Godai as voiced by him before the OSD vigilance and other officers of the vigilance wing of WBSEB. Sri Godai is stated to have played a cassette in support of his allegation, which prima facie convinced them and led to decision to lay a trap. He stated that on their asking, Sri Dinobandhu Godai submitted a written complaint by Exhibit 1. Complaint allegedly signed it in his presence. This is how they are proving it. Now, this person is not a member of the trap team. Is he not the independent person to prove it? Because they are bringing home the charge against me. He says that I told him, so at his instance, the complaint, it was prepared and Dinobandhu Godai signed it.
No, the concept of independent witness is known to a criminal trial. If you read this, I understand. Had it been a civil case, I understand the author of the document must prove
it.
Or even in a criminal trial.
In a process
Suppose
known to law.
I'm talking about a report of the PM report, post-mortem report. The author must come. The autopsy surgeon who has prepared the report, he must have a report as sent to the court from the QDB, question document. That the person who has prepared the report on the basis of the handwriting or chemical examination, he must come. But try to visualize try to visualize in a proceeding for eviction of a tenant, either under the transfer property or the West Bengal Premises Tenancy Act. In order to prove a notice of eviction, the lawyer has to come to the box. No. The PW1, there is a plaintiff who say that is on my instruction, my lawyer has signed it.
Because
I
my lord,
prepared it, he has signed. I have seen my signature. I have seen his signature. He put my signature.
True, my lord. But this case, my lord, this is a case where, my lord, the complaint is, my lord, the total
No, no,
foundation of the case, demand of bribe. What is
No,
the
sir.
complaint? That
If
I have
I-
asked for bribe.
Mr. Banerjee, try to visualize. I know I am troubling you.
No, no.
If you
Better, my
read
lord.
if you read the last portion of the paragraph 14, just cited
My
here, a document does not prove itself. Absolutely. In the inquiry, therefore, the contents of the relied on document have to be proved by examining a witness having knowledge of the contents of such documents and who can depose as regards authenticity.
My lord.
The Honorable Supreme Court does not say that the author of the written complaint has to come. Who it has been said, a document does not prove itself in the inquiry. Therefore, the contents of the relied on document have to be proved by examining a witness having knowledge on the contents of of such document and who can depose as regards authenticity. Now, keeping in mind such and such, he stated on their asking, Dinabandhu Garai submitted written complaint by Exhibit 1. The complainant alleges signed in his presence. Exhibit 1/2 is signature of such and such, and exhibit of such and such.
Now, what is
So,
may I explain, my lord? What is the complaint? Complaint is that the accused person has asked for bribe from Dinabandhu Garai. Now, whether that is the allegation, the authenticity of that demand of bribe, how can a third person, my lord, can justify it? A person competent to depose about its authenticity. Now, the authenticity of, my lord, this allegation that demand was not sought for.
no, we are talking about the authenticity of the
demand.
Authenticity of the proof of the authenticity of the written complaint.
Content also, my lord. Content is, my lord, demand of bribe. So the person must be competent to depose about its authenticity. Now, demand of bribe, a third person, in my humble submission, Lord, I'm troubling your lordship, but in my humble submission, Lord.
No, it's not troubling, it's an academic discussion.
Content is, my lord, demand of bribe. Because that is the foundation of the entire proceeding. Demand and acceptance. Acceptance they are seeking to prove by way of the trap program. But demand of bribe is, my lord, the complaint. Now, demand of bribe, how can the third person depose about its authenticity?
Mr. Banerjee, on
because
the,
I am not getting a
you
chance
can
to
recollect on the last occasion that the written complaint, which may be the basis of the which is the basis of a initiating of a PS case
My lord.
of a cognizable offense, that itself is not a substantive evidence. So how do you think that the written complaint that is very much required to prove even in a disciplinary proceeding?
Very well, my lord. If the written complaint goes, my lord, if the complaint goes, then the asking of bribe goes. I said on the last occasion, I'll show your lordship, my lord, what is the finding of the inquiry officer. It is relying on the inquiry of, on the demand of bribe.
Giving and taking money does not go.
Unless there is a demand for bribe. Taking money also I have shown your lordship, my lord, that the complainant, there's total, my lord, incongruity because the complainant himself says that he has not given it to him, which is the case
in a criminal proceeding.
Criminal proceeding.
That is different thing.
So my lord, there's a huge discrepancy in that evidence. But apart from that, my lord, asking of money, because unless they can prove demand of bribe, how, my lord, charge under, my lord, Prevention of Corruption Act can be proved, or, my lord, asking of bribe and taking of bribe can be proved. If asking of bribe is not proved,
that is
money is found.
That can be a very way. That can be a subject
On
matter of
presumption, my
argument.
lord, it cannot be done.
That can be a subject matter of argument in a civil proceeding, Mr. Banerjee. But so far disciplinary proceeding is low, scope is very limited. Definitely, these judgments are in your favor.
Lord, apart from that, I say, my lord, that that paragraph 14, my lord, the authenticity of that particular, my lord, allegation, content is, my lord, asking of bribe. And this person, this, my lord, OSD vigilance, he cannot, my lord, depose about its authenticity because the same paragraph 14 says that I have to cross-examine that particular person who is proving it. Now, if he is having no knowledge about the demand and I am not getting a chance to cross-examine, my lord, the complainant, then my right, it's a violation of Article 311(2). This is a violation of natural justice because content he is not competent to prove. That is what the court possibly has laid down, that the person should be competent about its the contents of the complaint. No, he is not. He can only say that he has signed. The signature can be proved, but the content, what is the allegation, he cannot prove that. Because in my humble submission, it's not a mere complaint like a criminal case because an offense is committed. If from other evidence, offense can be proved, but here, the foundation is not the asking of bribe in the disciplinary proceeding, and that has been completely not been proved because of the absence of the complainant. And they are
asking of bribe can be proved by otherwise circumstantial evidence. If it is proved that he has taken the money, asking is proved as a natural corollary.
Taken the money, my lord, taken the money, the sum of 21,000. If the money is found in my possession, that itself doesn't prove that I have asked for bribe and accepted the money. I can have rupees 21,000. It is not such a substantial sum.
No, in a trap program it was found that it was
trap program. And that trap program, the evidence I have shown your lordship, that's completely it falls apart.
That is different.
Because apart from the criminal proceeding finding.
Any other point, Mr. Banerjee?
My lord, on the same proposition, I have shown the Supreme Court judgment on the last day, my lord, that is also regarding complainants not coming because right of cross-examination is taken away, which violates Article 311(2). Because 311(2) says in departmental proceeding, full opportunity of hearing, which includes, my lord, the right of cross-examination has to be given. If witnesses are not brought, so my lord, in my humble submission,
Mr. Basu is saying,
how long it will go?
You can read what I may say. One another matter is fixed or earlier said fixed period.
yes, you are appealing.
No, I think next one. That's why I'm calculating.
But your roommate is arguing. Don't make interruption.
I'll just not point out. I'll file short notes so that all the points are not because
Not required, sir. I have taken note of it.
I'll point out the fallacies in the inquiry report. There are two parts of the inquiry report, which was followed by a second show cause note. The authority gave accepted the findings and gave me a second show cause notice. Second show cause notice also
before imposing punishment.
I'll show the incongruity in those inquiry report and the second show cause notice. In my humble submission, the points first is that the two sets of witnesses are contrary, that is, I have already submitted. Then marking of exhibit, which forms the basis of the inquiry, which is not proved by the complainant. Court has said the inquiry officer has said that the other witness has proved that is sufficient. Then, my lord, the cassette, which is a conversation between the charged officer and the complainant, that was also, my lord, marked as an exhibit.
Cassette was exhibited?
Exhibited, yes. And proved by PW4. Now, how PW4, now kindly, this is not at page 216. If your lordship kindly comes to page 216 once, my lord.
Writ petition.
Of the writ petition.
Page 216.
Kindly see how they are proving it. What occurs kindly when it comes to in the middle portion, 1, 2, 3, 4, 5, 6, 10th line, what occurs to me at the end?
Yes.
What occurs to me is that the prosecution was under the impression that they would prove the cassette through Sri Dinabandhu Garai, who allegedly produced the cassette, which allegedly contains the recorded conversation between him and CO. That would have been the best way to adduce it as a material evidence exhibit if Sri Dinabandhu Garai could be examined at all. But Dinabandhu Garai avoided being examined in spite of all efforts by the prosecution to produce him, to depose to facts within his knowledge, which I have discussed in the previous paragraph. Left with no choice, the prosecution therefore proved this material exhibit, received the cassette by re-examination of PW4, and it was heard that day in presence of all thereafter. Petition submitted by the defense was duly considered and order passed thereon by allowing the prosecution to prove it. So, PW4 has proved it by re-examination. This is not the way, because PW4 has got no personal knowledge regarding the voice of the charged officer or the complainant. He cannot depose about the authenticity of the voice. Then next point is the contract the contradictions in witness, two sets of witnesses, and DW1, the owner of the lodge, has been sought to be explained by the seizure list. What the inquiry officer is said is that since the seizure list is prepared, so everybody has signed it, so it is proved. The contradiction doesn't matter. Only, but the maker of the seizure list is the SI of police, who says that the money was lying in the court and the WBSD official have given the money to me. So the essential case made out that the money was given to him and he was standing with the money. That contradiction was done away with only on the ground that seizure list was there. Page 227, my lord. Records that there are contradictions. Kindly see 227, my lord, second paragraph. I have shown to your lordship that PW1 has said, my lord, who were the persons present in the room. The DSP was present as per PW1. DSP said, I have entered after the incident. Kindly see, my lord, how it has been proved. Exhibit 6 does away with everything. পুরোটাই তো দুরকম, দু জায়গায় দুরকম। অত আমরা we cannot request the court authenticity.
PW, such a contradiction between the statement of PW3 and PW7 is normal.
No.
In the normal run things, it was not possible. Obviously, the phase of tension.
7 and 8 are the police personnel. 8 has prepared the seizure list. 7 has not seen anything.
Very good. Any other point?
Now, my lord, DW1, who is the owner of the lodge, since I was staying there for some time, the inquiry officer said he is not a trustworthy witness. He is also not a bit too harsh because he has deposed. There might be incongruity, but calling him a
PW1 is the owner of the lodge.
So, specific finding at page 229 that he is not a trustworthy witness because he was staying there. So these are the small instances. I am not going into everything.
How can I reassess this evidence? I'm not hearing the first appeal or the second appeal, no.
I understand, Lord, it cannot be done.
Reassessment of evidence, that is not permissible.
Mile.
I believe you have covered all the points.
May I, my lord, just rely on one judgment or one more judgment on reassessment. This is a 24th judgment, my lord, 2024, volume 6.
Don't burden me with unnecessary judgment.
Only on reassessment. How far the court? High courts can do only on that proposition. 24, volume 6, SCC 418.
Will you repeat please the citation?
2024, volume 6, SCC 418.
Volume 4.
No, 24, volume 6.
Oh, I'm sorry. SCC?
SCC 418. Paragraph 29.
2000, yes.
Not kindly.
Paragraph 29.
Paragraph 29, my lord. No, I'm just only giving paragraph 29. As regards the power of the High Court. It is permissible, my lord, but there has to be, my lord, incongruity which is greater than, my lord, infirmity greater than normal. That is the standard set in this judgment, my lord. জজমেন্টের কপি আছে এটা কে বন্দ্যোপাধ্যায় ওটা ওটা দেখিয়ে দিন
This is not in connection with any disciplinary proceeding.
No, reappreciation of evidence on that. In 226, how far the court can reappreciate evidence. It might arise from a tribunal's order because the finding is also on order of tribunal being reassessed. The principle is that so far as reappreciation, how far the court can go, it can be done if the incongruity or the infirmity is much greater than normal. That is the standard set here. So, your lordship is looking in. I am grateful your lordship is looking into some parts of it because I have shown my lord all the parts which are my lord glaringly my lord which are the my lord infirmities in the order. That is why, and I am not placing the evidence, the order which takes note of those my lord evidences. So, my lord, I'll just summarize. My lord, the order of the disciplinary authority also my lord suffers from same my lord irregularities, my lord. The lack of chemical test, fingerprint expert, everything has been dispensed with. I've submitted that on the last occasion also, my lord, that in such kind of a my lord proceeding, the criminal court has also taken note of. Why you have not done a, my lord.
The Supreme Court in the reported decision have kindly taken note of it. The Supreme Court in the reported decision of 2000 Volume 1 SCC 416. 2000 Volume 1 SCC 416. 416. High Court of Judicature at Bombay versus Sasikant S. Patli. The Supreme Court said, but we cannot overlook that the departmental authority is the sole judge of the facts if the inquiry is properly conducted. The settled legal position is that if there is some legal evidence on which findings can be based, then adequacy or reliability of that evidence is not a matter for canvassing before the High Court. In a writ petition, file an article.
I accept, my lord. To that, my only submission would be
you have to accept. It's a Supreme Court judgment.
No,
Both you and me have.
There might be some further developments because the GM Tunk and the 24th judgment gives another dimension, adds one dimension. And
Already we have concluded, sir.
My lord, these are the points for disciplinary
One
authority.
thing I like to add, Mr. Koleas is saying that appeal is pending. How
No.
does it affect you?
Appeal was.
I have twofold submission.
No, you will get your chance, Mr. Koleas.
Appeal was disposed of, my lord.
No. Kone appeal?
C59.
Kone appeal?
Oh, appeal against the criminal.
Yes.
Maybe. Is there any stay? If there is
So
a stay,
therefore,
then
all these judgments not applicable. This judgment was the appeal court was final.
tendency of an appeal
and
does
they-
not amount to stay.
So that I'll submit.
Settle proposition. So he'll have to show that it has been
Yes,
stayed.
Mr. Kole.
And not one more thing, but I'll just, if he relies on this, I'll distinguish because the judgment of the Supreme Court.
Yes, Mr. Kole.
I rely on this.
My lord, my first submission, so far my learned friends will not heavily relied upon that complainant is not present. He has not give witness. Therefore, complaint is gone. My lord, what is the complaint? Complaint is he is asking bribe. Kindly catch him caught him red-handed. So, my lord, demanding bribe is, if I may say so, my lord, demanding bribe is not offense. But taking bribe is an offense, which has been substantiated by the, my lord, trap program. So far, complainant witness is concerned, my lord, that I will come, whether it is at all required or not. In my respect to submission for the timing, my lord, demanding bribe is not offense. I am asking for money. But, my lord, the taking bribe, your lordships kindly consider. Taking bribe is an offense and which has been substantiated by the trap program and he has got red-handed. This is number one. Number one. So far, the complainant present is concerned. My lord, kindly come to the writ petition. My learned friends, clients, my lord, file a writ petition on the same prayer.
In an earlier round of litigation.
Yes. Therefore, my lord, the question raised by learned friends in my respectful submission is an res judicata. He cannot raise this point. So far, the presence of the complainant. I am with the, my lord.
So this is the second writ petition after the acquittal.
No. So far, the complainant presents before the disciplinary authority. Since complainant is not present, my learned friends client filed a writ petition saying that disciplinary proceedings should be stopped. As because he is the first witness. My lord, paragraph 32 of the writ petition, it is amendments made by my learned friends clients. Paragraph 32, page-টা বোঝাই যাচ্ছে না. Page 19, 20. Copy of the said order. My lord, may I place it?
Paragraph number 32.
32. My lord, that inter alia challenging the notification dated 30/2004 being annexed P17, the petitioner filed an application under Article 226 of the Constitution of India before this Honorable Court being WP number 9481 W of 2005, Sri Gopal Chandra Niyogi versus WBSC DCL. The said application was moved before His Lordship, the Honorable Justice Kalyanjyoti Sengupta, when after hearing the respective parties, His Lordship was pleased to pass an order on 8/6/2005, inter alia holding that prima facie the impugned notice was not in accordance with such and such departmental proceedings, attendance of witness and process such and such 73. His Lordship was pleased to further pass an interim order directing that the disciplinary proceedings would continue and that there was no question of closure of departmental proceedings, nor there are question of granting stay. His Lordship was pleased to further direct that in the event witness concerned voluntarily appeared before the inquiry officer either by way of persuasion or otherwise, and not in terms of the notice, then the writ petition would stand disposed of without passing any order whatsoever. This order, your lordships kindly come to page 193. And therefore, thereafter that writ petition was disposed of. That has not been, my lord, brought into the notice of this honorable court.
Page 193.
193 is the order. The operating portion, my lord, page 195. No, it's a very, it's not clear. Order to pura jacche. I make it clear that the disciplinary proceedings will continue and there is no question of closure, departmental proceedings, nor there is question of granting stay in the event the witness voluntarily appear before the inquiry officer, such and such, persuasion otherwise, and not in terms of this notice, then this writ petition will stand disposed of without passing any further order. Whatever in the voluntary intimation to this court, yes, an intimation should be given to this court to that effect. Thereafter, my lord, I have searched out that this petition was disposed of in the year 2015. These writ petitions filed by my learned clients.
So how it becomes a res judicata?
My lord, the same question, challenging the same question, my lord, this writ petition was filed. Since the complainant was not, my lord, appeared before the disciplinary authority, the disciplinary proceedings should be dropped because I have not been given chance to cross-examine. Therefore, my lord, how that question can be raised again in the writ petition?
No, Mr. Kohli, read first paragraph of 193.
My lord, in the matter, the order, yes. In this matter, at this stage, the petitioner has taken 2 points. Firstly, that the disciplinary action cannot continue continuously with the criminal proceedings. That is one aspect. Based on the same set transaction. Secondly, the notification issued by the government for compliance in the concern,
compelling witnesses concerned
to give attendance. That is the the petitioner, complainant, before the inquiry officer is not in accordance with the provisions of the departmental proceeding, enforcement of attendance.
Oh, in this writ petition, in the earlier round of litigation, 2 points were under challenge.
Yes.
One is continuance of the
Criminal proceedings and
during
the,
the pendency of the criminal proceedings.
Yes. And second, my lord,
is the notice, the government notification regarding attendance of the witnesses.
Yes. Complainant. Here, my lord, attendance of the witness means complainant. The writ petition was not with me.
Oh, has they approached this court in the earlier round of litigation for practically for quashing of the proceeding on account of non-examination of the complainant?
Well, that writ petition is not with me. I was not there. From the order, I can make submission.
Then how do you justify your contention with regard to the point of res judicata?
Well, that I will.
The point of res judicata, Mr. Kohli. The matter in issue, which is substantially same with the previous matter.
Yes, yes, yes.
That is to that. Those are res judicata.
Yes, my lord, that.
The basic concept of section 10.
Yes, yes.
11.
My lord, that it was. Anyway, my lord. So, my lord, so far the, my lord, the presence of the witness is concerned, a past complainant. So, my lord, my respectful submission, my lord.
11, no court shall try any suit or issue is a matter being directly or substantially in issue, has been directly or substantially in issue in a former suit between the parties. That is section 11.
Yes, yes. So, my lord, in my respectful submission, that writ petition, they have challenged that also.
Very good. Next point.
And my lord, second thing is, my lord, the trap program, the taking bribe is established and he has been caught red-handed. So, my lord, whether the complainant witness is necessary or not, so far my learned submission is concerned. The Supreme Court says other witnesses corroborated the fact. Recent judgment of the Supreme Court 2025, my lord, I placed before your lordship right now that everything will clear in my respectful submission. My lord, kindly allow me to place this judgment first. So far, the reappreciation of evidence, whether with the scope of judicial review, I shall submit, my lord, later on. there are several judgments, including the criminal proceedings, that I will submit before. So far, the first question is concerned whether complainant witness is required or not.
What is the citation, Mr. Kole?
Yes, 2025, 4 Supreme Court cases, 111. But I will not take trouble to your lord.
Triple one.
Triple one. This is the latest Supreme Court judgment where the so many judgment has been considered by this court.
Paragraph, sir?
Yes. Paragraph 31, 32, 33, and 35, 36, 37. 38 also. My lord, may I please? Further, we are unable to sustain the findings of the division bench that the non-examination of the complainant is fatal to the case of the appellant authority. It is well settled principles of law that even in a criminal case pertaining to demand and acceptance of illegal gratification, the court are empowered to record conviction where the docky turns hostile, and the prosecution case is based purely on the evidence of the trap lying officer and the trap witnesses. In this regard, we are benefited by the judgment of this court in such and such, your lordship, wherein it was held thus, SCC Online, SC Para 7. It is now well settled by a series of decisions of this court that while in a case of evidence of an accomplice, no conviction can be based on his evidence witness unless it is corroborated in material particulars by particulars. But as regards the evidence of a partisan witness, it is open to the court to convict an accused person solely on the basis of the evidence if it is satisfied that the evidence is reliable. Next, in the case at hand, the subject matter concern of domestic inquiry, where the strict rules of evidence prohibiting admissibility of concessional statement recorded by the police official do not apply. Likewise, non-examination of the docky cannot be treated to be fatal in the domestic inquiry, where other evidence indicates the delinquent officer. As has been held by this court in Narendra Singh, even a confession of the delinquent employee recorded by the trap lying officers during the criminal investigation can be relied upon by the disciplinary authority. Well, this is pat on the point. It is pertinent to note that the trap lying officer, D.N. Biswas, was examined during the course of disciplinary proceedings as PW2, and he supported the case of the appellant authority to the hilt. The evidence of PW2 was substantially corroborated by the other departmental witnesses, including PW1, Mr. S.K. Dasgupta, Assistant Commissioner of Police, such and such, and PW3, Mr. such and such. Thus, the division bench clearly erred in holding that non-examination of the complainant was fatal to the disciplinary proceedings conducted by the appellant authority. Next, my lord, 35. It is tried law that in disciplinary proceedings, it is not necessary for the disciplinary authority to deal with each and every ground raised by the delinquent officer in the representation against the proposed penalty, and detailed reasons are not required to be recorded in the order imposing punishment. If he accepts the findings recorded by the inquiry officer, our view stands fortified by the decision of this court in such and such. Further, it is well settled that if the disciplinary authority accepts the findings recorded by the inquiry officer and passes an order, no detailed reasons are required to be recorded in the order imposing punishment. The punishment is imposed based on the findings recorded in the inquiry report. As such, no further elaborate reasons are required to be given by the disciplinary authority. All that is required on the part of the disciplinary authority is that it should examine the evidence in the disciplinary proceedings and arrive at the reasons conclusions that the material placed on record during the course of inquiry established the guilt of the delinquent employee on the principles of preponderance of probabilities. That's the spirit of the disciplinary preponderance of probabilities. This is precisely what was done by the disciplinary authority and the appellate authority while dealing with this case of the respondents. In our considered view, the division bench fell into grave error in substituting the standard of proof required in a criminal trial vis-a-vis the disciplinary inquiry conducted by the employer. It is a settled principles of law that the burden laid upon the prosecution in a criminal trial is to prove the case beyond reasonable doubt. However, in a disciplinary inquiry, the burden upon the department is limited and it is required to prove its case on the principles of preponderance of probabilities. My learned heavily relied upon the criminal judgment. However, that was challenge and appeal. In this regard, we are benefited by the judgment of this court, Union of India and such and such, such and such. As disciplinary proceedings is not a criminal trial, the standard of proof required is that of preponderance of probability and not proof beyond reasonable doubt. If the interfere that Nandkumar was a person's like, yes, if the inference that the Nandkumar was a person's like to have official deal with such and such respondents was one of the reasonable persons would draw from the proof fact of the case, the High Court cannot sit as a court of appeal over a decision based on it, where there are some relevant materials, my lord, kindly causing here for a moment. There are some relevant materials where there are some materials, relevant materials which our authority has accepted and which materials may reasonably support the conclusion that the officer is guilty. It is not the function of the High Court exercise its jurisdiction under Article 226 to review the materials and to arrive at an independent findings on the materials. If the inquiry has been properly held by the question of adequacy of reliability, and the evidence cannot be canvassed before this court. So here, my lord, the disciplinary proceedings was conducted thoroughly. We find that the learned single judge, while dealing with the writ petition filed by the respondent against the order passed by the disciplinary authority and the appellate authority, considered the entire factual matrix in details and dismissed the writ petition preferred by the respondent by details order dated such and such. Therefore, my lord, the Honorable Supreme Court upheld the judgment of the Honorable Single Bench, paragraph 44.
44 or 40?
40, and my lord, ultimate conclusion, paragraph 44. As the upshot of the above discussion, we find that the impugned judgment dated such and such passed by the division bench of the High Court is unsustainable in the eye of law. The same deserves to be and is hereby set aside. The division bench held that the complainant is not give evidence, therefore. But single bench says no, complainant evidence is not required. Therefore, single bench judgment has been upheld. So, my lord, this judgment is, my lord, covers entire the things we pat on the point of this case. Now, my lord, without going into factual aspect, my lord, so for the scope of judicial review. Now, this is 2022 SCC Online SC 1617. এটা দিন জজ সাহেবকে।
পেজ নাম্বার স্যার
My lord. 1617. My lord, paragraph 14, 15, 16, 18, 24. Now, paragraph 14. It is well settled that court ought to refrain from interfering with findings of the facts recorded in a departmental inquiry, except in circumstances where such findings are, my lord, patently perverse or gross imperturbable, with the evidence on record based on no evidence. Kindly, my lord, mark. Based on no evidence. However, if the principles of natural justice have been violated or the statutory regulations have been adhered to, or there are malafide attributed to the disciplinary authority, then the court can certainly interfere. The next, my lord. In the above context, following are the observation made. My lord is concluding today. No, my lord, I have no difficulties, but my lord is not.
No, please conclude, sir.
No, one submission, may I have one interrupt? 32, just
Sir,
today.
don't interrupt, sir. I'm in the midst of hearing.
Now, my lord, next. In the above context, following are the observation made by the three judges bench of this honorable court in BC Chaturvedi Supra. Judicial review is not an appeal from the decision, but a review of the manner in which the decision is made. Power of judicial review is meant to ensure that the individual receiver receives fair treatment and not to ensure that the conclusion which the authority reach is necessarily correct in the eye of law of the court. My lord, kindly consider, kindly, my lord, pausing here for a moment. When an inquiry is conducted on charges of misconduct by a public servant, the court stroke tribunal is concerned to determine whether the inquiry was held by a competent officer or whether rule of natural justice are complied with, whether the findings of the conclusion are based on some evidence, the authority entrusted with the power to hold inquiry has jurisdiction, power and authority to reach a finding of the facts or conclusion, but the finding must be based on some evidence. Exactly, my lord, here only one absent of the petitioner, otherwise all their evidence are there. Neither the technical rules or evidence act nor of proof of the fact of evidence as defined therein apply to disciplinary proceedings. When the authority accepts that evidence and conclusions receive support therefrom, the disciplinary authority is entitled to hold that the delinquent officer is guilty of the charge. The court tribunal is the power tribunal in its power of judicial review does not act as appellate authority to reappreciate the evidence and to arrive at its own independent findings on the evidence. The court tribunal may interfere where the authority held that the proceedings against the delinquent officers in a manner inconsistent with the rules of natural justice or in violation of statutory rules prescribed in the mode of where the conclusion of finding reached the disciplinary authorities based on no evidence. If the conclusion of finding be such on no reasonable persons would, however, reach the court of tribunal may interfere with the conclusion of the findings and mold the relief as to make it appropriate of the facts of the case.
So the appreciation of evidence is not permissible.
Well, it's very limited. That Supreme Court will a series of judgment. This is also recent. Will three judges when judgments also considered, and everything was considered by the Supreme Court. Next, a review of the above legal position was established that the disciplinary authority and the appeal of the appellate authority, being fact-finding authority, have exhaustively power to consider the evidence with a view to maintain discipline. They are invested the description of the imposed proportionate punishment, keeping so far the scope of the judicial review. I think, my lord, I will not cite it. I will not, my lord. Another judgment, my lord, I can show to your lordships. This is same proposition was, my lord, held.
If it be on same provision, don't give, sir.
So far the scope
If
of
it is same provision, don't give.
Fine.
And don't
Man.
unnecessary burden.
Unnecessary pardon. I bow down your lordship. My lord, another judgment I cited before your lordship, 2020 9 Supreme Court cases 471. My lord. Para, my lord, 28, 29, 30, 31, 32, 33, 34, and 35. এটা জজ সাহেবকে দিন। Yes, my lord. And exactly this was relied upon by your lordships in one judgment that I will place before your lordships.
Me?
Yes, my lord, in one of the cases. I believe I'm just yes, my lord. Praveen Kumar versus Union of India 2029 Supreme Court cases.
Yes, sir. Para 28, you said.
Well, but I have
Yes.
It is thus well settled that the Constitutional Court, while exercising their power of judicial review, would not assume the role of an appellate authority. This jurisdiction is circumscribed by limit of the correcting errors of law, procedural errors leading to manifest injustice, to violate the principles of natural justice, put difficulties. Judicial review is not analogous to venture into the merits of the case like an appellate authority. Therefore, 29, 30, all these paragraphs is there. 31, I have not trouble your lordships. 31, last portions, while strict rules of evidence are inapplicable to disciplinary proceedings, inquiry officers often put question to witnesses in such proceedings in order to discover the truth. Indeed, it may be necessary to do such direct questions into certain circumstances. Further, the learned counsel to the appellant accept the making of bold allegation that the inquiry officer had questioned the witnesses did not point in any specific question, but such these are not so relevant. Effect of criminal inquiry of disciplinary proceedings.
Very pertinent.
Yes. The incident of 28 to 1999 raised serious question of criminality under the Penal Code and the Prevention of Corruption Act, as well as the violation of service regulations and administrative contact. Thus, in addition to appointment of inquiry officer, the authorities also registered a criminal complaint with the CBI. After investigation, the CBI thought, though did not find adequate materials to launch criminal prosecutions against the appellant, but though itself speaking, a report dated 7/3/2000, the CBI recommend major disciplinary action against the appellant and a few others. It is beyond doubt that criminal proceedings are distinct from civil proceedings. It is both possible and common in disciplinary matters to establish charges against a delinquent officials by the preponderance of probabilities and consequently terminate his service. but the same set of evidence may not be sufficient to take away his liability under our criminal law jurisprudence. Such distinction between standard of proof amongst civil and criminal litigation is deliberate. Given the difference in strike, the power imbalance between the parties, and the social cost of an erroneous decision, thus, in a disciplinary inquiry, strict rules of evidence and procedure of criminal trial are applicable. Like, say, statements made before the inquiry officers can be relied upon in certain instances. Thus, the appellant's contentions that he should be exonerated in the present proceedings as no criminal charges or charge sheet was filed by the CBI after inquiry is liable to be discarded.
Mr. Kohler, it is little bit.
No, Milord, relevant means, Milord,
Mr. Banerjee placed reliance that when disciplinary proceeding and criminal trials are based on self-same facts.
Milord, so far the criminal proceedings
Please
concerned.
listen to my question, sir. Mr. Banerjee's contention was, if I have correctly understood, that in the event both the disciplinary proceeding and the criminal proceeding are based on self-same facts, and self-same evidence was laid both in the disciplinary proceeding and criminal proceeding, and in the event on the basis of the appreciation of evidence in a criminal trial, the accused has been honorably acquitted, that must be that acquittal order, that the judgment of acquittal rather, must be an advantageous effect in favor of the delinquent over the disciplinary proceeding.
My lord, so far the judgment of the criminal, yes, I understood. So
But
far
it is a little bit different.
but my lord, so
Charge sheet has not been submitted.
no, I am the principal. So far the Milord criminal court judgment is concerned, neither the
Are you fortified with any judgment with regard to that?
my lord, I'm coming. Neither the disciplinary authority has occasion to consider. This is one aspect. Another is, my lord, that was appeal before this honorable court, the appeal was pending. So, my lord, unless, my lord, appeal is a continuation of suit, your lordship knows, my lord. We cannot, my lord, confine hearing that this judgment is, my lord, concluded. Unless the appeal court's judgment is, my lord, taken into consideration. My lord, two things. The disciplinary authority has no occasion to consider the judgment of the criminal court. This is number one. Number two, the judgment of the appeal criminal court is pending before the appellate authority. Therefore, my lord, this should not be taken into consideration. Your lordship should confine.
Law is very settled.
Yes.
When a judgment of acquittal is challenged before a court of appeal,
my lord,
they are the acquitted accused comes to the presumption of his innocence.
No, the presumption is similar different. I am not on that. Presumption. So, my lord, so far the disciplinary authority is concerned, my lord, there is no occasion to consider the
This is a settled principle of criminal law.
My lord, presumption.
When an judgment of acquittal is challenged before a court of appeal,
yes,
in that appeal, that acquitted person, acquitted respondent, comes with the presumption of his innocence.
My lord, so far presumption is concerned, my lord, that I can write now, but my lord, I can say that these two things, your lordship should.
I understand your concern. What have you got to? Are you fortified with any judgment that when what is the Mr. Banerjee's contention that when criminal trial and the disciplinary proceeding are based on the self-same facts, and where identical set of witnesses have been examined, and where in a criminal proceeding the delinquent accused was acquitted honorably, that has an advantageous effect. How do you distinguish that? Do you want to come back?
Yes, my lord, because the recent, so far, my lord, I know, latest Supreme Court judgment has, my lord, to this point, it's 3 judges benches is there. That was not right.
With you. It is with you.
Right now, my lord, it's not
Come back.
with me.
I'm giving you the opportunity.
My lord.
Tomorrow.
Yes, my lord, tomorrow.
Tomorrow, sir.
My lord, your lordships kindly give at least 2-3 days time. So because my learned friend is cited so many judgments.
Sir,
No, no, your lordship memory, my lord, I know your lord, so far the deployment, my lord, so far the, no, no, my lord, so far this case is concerned, I know your lordship's memory is very sharp. So far the, my lord, this scope of judicial review, because your lordship has already passed so many judgment. Yes. Man, my lord, I had an occasion to appear before your lordships at 3-4 cases.
No, only one.
Not tomorrow, my lord. Day after tomorrow.
No, only one point, but let him address that also. I pointed on the last day. Today I missed. No, only one thing, my lord. No, I missed it, my lord. Today, previous day I pointed out that Payment of Gratuity Act, they have forfeited the gratuity. Payment of Gratuity Act lays down certain provisions, circumstances when gratuity can be forfeited. Loss caused to the corporation or any such circumstance. That is, my lord, not present in this case. Section 4 has
Loss Supreme Court says loss.
Endeavor.
Man. Of course.
Almost 20 to 24 hours left. So we will make an endeavor.
Yeah. What item?
Okay, 29.
No, item.
I assure you that I will not put Mr. Cole in trouble.
That not only me, my lord. So far the member of the bars, my lord, that my lord, we can assure that your lordship is always accommodating.
He is assured. আচ্ছা এই জাজমেন্ট গুলো পিটিশনাররা যারা করেছেন সেটাকে আলাদা একটা ফাইলে করে দেবেন আর রেসপন্ডেন্ট যারা করেছেন সেটাও একটা আলাদা ফাইল নালে মিশে গেলে মুশকিল হয়ে যাবে হ্যাঁ পাঠিয়ে দিন দেখে নেবো এই অর্ডার শিটটা পাঠাতে হবে একটু না
আসতে পারবো
প্লিজ স্পেয়ার মি ফর 2 minutes
কম্পিটেন্সি
হ্যাঁ তোমাকে তো আসল
আরে অ্যাওয়ারমেন্ট কিছু কিছু
My lord, today Mr. The learned Advocate General was about to address my lord to an extent on behalf of KMDA. My lord, he requested for a small accommodation for tomorrow, if my lord may kindly take it.
Accommodation is not expected.
Because my lord, he is on his
Mr.
way.
Talukdar was advancing argument.
No, perhaps not. My learned senior friend has advanced argument. My lord, may kindly take it up.
A very unfortunate state of affairs.
This is
My lord, may just take it up tomorrow, my lord. I am extremely.
No, that I have understood.
আরেকটু নামটা দেখে দেবেন, মেহতা করে দিচ্ছেন, এমই নয়, MAHATA। আগের দিন একটা ভুল দুটো ঠিক আছে, একটা ভুল আছে। My lord is looking into.
How page number 6 and 6 can be, how do you do the work? Kindly read page number 5 and 6. I believe wrong page has been incorporated here.
দুটো পেজ চলে এসছে, 10 পেজ twice. One can be
Six has been
doubly annexed.
Six has been doubly annexed.
No. After page number 5, there must be something.
After page number page
But
number
there are
six.
two page 6.
Page 6.
Six are there.
Two pages are there.
In the supplementary affidavit, my lord.
There are 2 pages numbered 6 after page 5.
দাও কিভাবে কাজ হয় বাবা।
নাম্বারিং করেছিস নাকি? ওদের অপোজিশনে 4 অবধি আছে।
But page number 6, my lord, is there.
কি হয়েছে?
ওটারটা এটা ঢুকে গেছে।
Take it back, file it tomorrow.
My lord.
আমি এটা রেখে দিচ্ছি, এটাই
হ্যাঁ, তোমারটাই ঠিক হবে। কি তাড়াহুড়া।
ফেরত দিয়ে দাও ভুল পাল্টা হয়েছে।
হ্যাঁ, গন্ডগোল করেছে।
Page number, actual page number 6 is missing.
Actual page number 6 is missing here.
এইটা
কম্পিটেন্সি ঠিক আছে, কম্পিটেন্সি ঠিক আছে।
আরে বাবা একসঙ্গে ফাইল করবে, নিও না ওটা।
হ্যাঁ, আমি একসাথে দেবো কম্পিটেন্সির সাথে। হ্যাঁ, ও আচ্ছা।
নোট করুন আর কি হবে, অন বিহাফ অফ দি KMD authority and Mr. Mara, kindly ask your clerk to remain vigilant. Otherwise, it is very difficult. এটা আমার কাছে পাঠিয়ে দাও।
Till such time, learned advocate general could have come. বল না কিছু তো বলতে পারলে বল না।
No, no, no. Let Mr. My lord, allow Mr.
It will be very difficult piecemeal submission.
Yes, yes, yes.
No,
Not as an counsel for care. My lord.
Otherwise, I am also ready, but when he is leading me, my lord.
My lord.